Right. With authority. Welcome, everybody, to today's regularly scheduled Minnesota Public Utilities Commission agenda meeting. Today is December 4th, 2025. We have 3 items on the docket for today. I will turn it over to our staff, Ms. Sally Ann McShane, to introduce the first matter. Miss, and thank you, Commissioner Tuma. I'm a little out of form, so thank you. I'm going to mix it up. I'm going to start with the role of myself. I'm here. Commissioner Tuma.
I'm here.
Commissioner Partridge.
Here.
Quorum is present. We are free to do business. Ms. McShane.
Good afternoon, Chair Sullivan and Commissioners. Item number 1 is 2 dockets. Docket number EG002/CI022034 in the matter of an investigation and audit of service quality reporting Broadway's report, and docket number EG002/M12383 in the matter of the petition of Northern States Power Company doing business as Xcel Energy for approval of amendments to its natural gas and electric service quality tariffs originally established in docket number EG002/CI022034. The questions before the Commission today are: 1, should the Commission accept Xcel Energy's annual 2024 Quality of Service Plan QSP report? 2, should the Commission approve Xcel's proposal to use 50% of the customer complaint underperformance penalty for bill credits to past due customers? And 3, should the Commission approve Xcel's proposal to use 50% of the telephone response time underperformance penalty for deployment of its live chat function? There were 3 late filings in the dockets on Tuesday, December 2nd. Commissioner Tuma filed an amended Decision Option 23 and a new Decision Option 25. Commissioner Partridge filed a new Decision Option 25 and a new Decision Option 26. And the Office of the Attorney General filed a new Decision Option 8A. The late filings have been e-filed and shared with all commissioners. I also have hard copies. Staff has no more comments, but is available for questions. Thank you.
Thank you, Ms. McShane. I will ask the parties to come forward. So I have on my list Xcel, CUB, and the Energy Sense Coalition. Well, there's George. Okay. All right. We are going to start with Commissioner questions, but I think what I'm going to do is just to get the naming stuff out of the way. First, we'll just start with people if you could just introduce yourself for the record, and then we don't have to scold you later for not doing that. We're going to start to my right, over here.
Good morning, Commissioners. Adam Bernowski with Xcel Energy.
Good afternoon, Riley Conlon, attorney, Xcel Energy.
Good afternoon, Commissioners. Nick Martin, Xcel Energy. We also have one other Xcel person on the WebEx, Deidre Howard, who's director in our customer care.
Good afternoon, Sydney Lieb with the Minnesota Department of Commerce.
Good afternoon, Joey Cherney with the Office of the Attorney General, Residential Utilities Division.
Good afternoon, George Shardlow with the Energy Sense Coalition.
Good afternoon, Olivia Carroll with the Citizens Utility Board of Minnesota.
All right, great. And then Ms. Howard, if you just want to turn your camera on and just tell us your name.
Good afternoon, Deidre Howard. I'm Director of Customer Policy and Regulatory Compliance at Xcel Energy.
All right, welcome. All right, we will start with Commissioner questions. Commissioner Partridge, the floor is yours.
Thank you. And I want to recognize, I know that there are questions from other commissioners too. I guess because we didn't have opening remarks, I think, first of all, I want to maybe just turn it to Xcel and ask you what is going on, with both of the metrics that you missed the mark on, both the customer complaints. I'd like to hear just your opinion on what you think is going on, and then the telephone response time.
Great, thank you, Commissioner Partridge, and thanks for the chance to be here today. And so let me talk a little bit about each of those. Well, first I'll say, so we never like to miss metrics, and we recognize that we've fallen short on both of these in 2024. The customer complaints metric, it was significantly over our standard. What's the primary driver of that is complaints in the billing and credit category. So that was about 1,083 of the 1,468 total. So about 3/4. And within that, a useful breakdown to keep in mind is how many were billing and how many were credit related or disconnection related. So 126 of those were billing related complaints. Clearly, we have some billing challenges that we're addressing in the separate investigation and making some good progress there, we think. 957 complaints, or 65% of the total, were related to disconnections. So, and we can talk more, I'm sure, in this hearing about what we think are the drivers of those disconnection-related complaints. That's clearly an area where, we have room for improvement. We do see potential to, in all the different areas where the company, really tries to avoid disconnections, both in the ways we work with our customers and then the additional measures that we've proposed in recent years to help customers avoid disconnection. We are certainly hopeful that the disconnection-related complaints from 2024 will be moving downward. So that's the complaints metric, and then telephone response time. As you know, the requirement there is 80% of calls answered in 20 seconds or less. We missed that by 0.3% last year. We mobilized quite an effort in the last sort of 6 weeks of 2024 to attempt to, assign more agents to Minnesota calls and a number of other things that Mr. Brunowski can talk to you about. But in spite of that effort, we did miss that metric by a little bit. We do think we're back on track with that one as far as we can tell from the data in 2025.
Okay. Okay, so going to the customer complaints, in talking with some of our CAO staff, I think one of the questions I had for them was, yes, you've talked about disconnections, but a person who receives a disconnection or is disconnected, who knows that they're behind on their bill, who calls in and asks for a payment plan and has a reasonable payment plan that they're able to enter into and then have their service reconnected, I asked them, why would they call and complain to us if that process was working? And what I was told is that the issue is actually that process around calling in, asking for a reasonable payment plan, and being able to reconnect service. So the complaints go, as I understand it, sort of a level deeper than just I'm being disconnected. And so I guess I'd like for you to speak to what you're doing on that matter, and I'll note that we did make changes around what you could require for a down payment in a previous docket. I'd like to know if that's been implemented and anything else you're doing to mitigate that problem that I've identified with our CAO staff.
Right. Thanks, Commissioner Partridge. So let me try to answer this one in a general way. It's really, Deidre Howard has even more expertise on this, so if I'm not able to fully answer, I'm sure she can. So let me start with what do we do and have we done for years to try to avoid disconnection when customers call in. So there's a 9-week process where if a customer is behind on their bill by a certain amount, and that amount now is $300, that's been so we don't disconnect at all if the past due balance is less than that. When they reach that point, kicks off a process where we're trying to connect with the customer multiple times over that 9 weeks to put them in contact with energy assistance from the state, refer them to our affordability programs for Xcel Energy, offer them payment plans, we have several flexible options around, custom due date, so they can set their due date when in the month they want it. Flexible payment plans. Ms. Howard can talk to you more about that. So there's a lot of things that we're trying to do to help the customer enter into a payment plan to avoid disconnection. In the service quality docket from last year, we worked with CUB and Energy Sense on a new set of measures, and you're aware of them. You referred to some of that, where the down payment required to enter into a payment plan has now been pushed down to 10% and can be less than that if we're in consideration of the household's financial circumstances or extenuating circumstances. So there's a lot of ways that we're, I think, trying to help a customer reach a payment plan that works that would avoid disconnection. Some customers ultimately still are not happy with the resolution they've gotten from us and reach out to CAO, and that's obviously their prerogative.
Okay. Ms. Howard, do you have anything that you'd like to add to that?
Yes, actually, and thank you, Commissioner Partridge. I would say that we also do a lot of outreach to customers that we see may be hitting a threshold where they might be in danger of disconnection. Last year, we did over 40 outreach campaigns via telephone. We also, at the request of commissioners and the Consumer Affairs Office this year, did put some additional information on our website for customers to refer to about what that process looks like, to make sure that they're aware, like if I get a notice at this point, here's the next step. And I would say we also have a department that's completely dedicated to customers that might have special extenuating circumstances, perhaps related to a medical condition or something along those lines. That department also can help walk customers through an energy assistance application and make those direct referrals to Energy Sense Coalition, who manages our Power On and GAP programs. I would say it's a very robust area. This is also a department that does a lot of work in advocating for those benefits. So I would say that in general, we're taking a lot of what I consider to be measurable steps to help customers avoid disconnection at all costs. That's our goal. And we have a department that's specifically dedicated to it. We also did a lot of work around identifying extenuating circumstances that is now part of a normal routine conversation in our contact centers as well. And happy to answer any other questions you might have.
Thank you. That's actually interesting. So the work that you've done around the extenuating circumstances, that also came up in my conversation with CAO staff, that folks are feeling like the down payments that they're being offered are consistent with the requirements under the previous docket, and I'm blanking on the number right now, but it is the 10% that they're being asked to pay. But we're hearing that folks who are having extenuating circumstances, they've lost a job, they're on a fixed income, et cetera, that they are not being given consideration to those extenuating factors. So do you have a written policy or something that you could perhaps file with the commission so that we could make that more transparent and review that process?
Ms. Howard.
Certainly.
Okay, that would be wonderful.
I'll take that down as an action item.
Thank you. Great. Let me just bump around. All right, I have several questions. Chair Sullivan, would you like me to just do you want to add on to that particular topic, or you want me to just run through all of them?
My plan was that I was just going to let everybody run with what they wanted to run with.
Okay.
So I was going to go to you first, and then go to Commissioner Tuma, and then do what I wanted to do at the end.
Great. Okay, I'll keep going. Okay, so I will just say, from my perspective, the nature of the complaints make them more concerning to me, because these are people who are struggling to pay their bills. They are reaching out to Xcel Energy. They are saying, I'm struggling. Here's the ways in which I'm struggling. And then they're reporting to us that they're not getting what they need from you all in order to reconnect their service and start on a workable, reasonable payment plan. I don't know if the OAG or the department, do you all have any insight into the questions I've asked? Anything to add? And it's okay if you don't. Okay. But you would be willing and interested in reviewing the extenuating circumstances policy documents?
Mr. Cherney.
Chair Sullivan, or Commissioner Sullivan, Commissioner Partridge, yeah, we would definitely be interested in that. I also know that CUB has done extensive work on this.
And maybe to Energy Sense Coalition and CUB, I have the same to you if you have anything to add or if you have interest in reviewing the policy.
Thank you, Commissioner Partridge. I think we similarly agree. We've also heard anecdotal evidence from customers over the last several months that following our agreements, customers still felt like there wasn't necessarily as much flexibility, but in communicating with Xcel, who've been open to communicating on those, checking in and reassuring us that there's training still going on and things like that. But we do hear those comments still, and we note that the company between January and October 2025 have already exceeded the disconnections from 2024. So we remain concerned on those as well.
Okay. So I'll just say from my perspective to kind of wrap this up, maybe I'll go back to it, but maybe wrap it up, is that, from my perspective, it is concerning. I don't really feel like I have enough information to get to the bottom of the problem or to understand if the problem will be fixed by the restrictions on down payments and the guidance you now have there, or the trainings and the policy you now have on extenuating circumstances. So I feel like we need to keep working with you and with CUB and Energy Sense and our agencies to make sure that we get to the bottom of the foundational issue, because whatever is driving the complaints, that's what we need. That's what we need to fix. And it seems like, as Mr. Martin identified, certainly this 65% around disconnection seems like the core issue that we're needing to deal with, from my perspective. I wanted to also then move to the telephone response time. And I think, there we may have some interaction with the volume of calls you're getting, but, with the previous metric. But again, I wanted to just touch on that. I think looking at staff's briefing papers on page 26, and thank you, Ms. McShane, for the briefing papers and all of this great context. It says, in 2024, non-IVR calls response rate within 20 seconds fell below 50% for Xcel. Meanwhile, CenterPoint Energy answered 82.7% of calls, excluding IVR, within 20 seconds. I think for me that was really quite surprising and really highlighted an issue that shows me that this can be achieved, that another very large utility with many, many customers has been able to manage this issue. And it made me wonder why this is not something that you can achieve. And I just want to note just the stark difference, almost 83% to less than 50%. You're not in the ballpark. So I guess from my perspective, what do you think you're doing differently? This is clearly an issue. So I guess I know you kind of gave me the overview that you've been assigning more agents. Did you get rid of a lot of agents? Was there a change operationally that caused this?
Mr. Martin. Oh,
I'm going to defer this to my colleague, Mr. Bernowski.
Mr. Bernowski. All right.
Thanks for the question, Commissioner Partridge. A combination of things. I think in 2024, we definitely fell short on our hiring and also had some increased attrition. So that was, I would say, the overarching issue in 24. Definitely an outlier year, not typical of our performance if you could look back over the years. And in 25, currently, we are definitely in much better shape than we have been each month of this year. In fact, the last quarter of 24, we were doing very well, but just not good enough to kind of get the overall annual 80%.
Okay.
So yeah, more of a staffing issue as opposed to letting staff go or that kind of thing. In fact,
Okay.
we didn't do that at all in the contact center.
Okay. Well, that is good to hear. That is makes me feel better about it. So with that, I'd like to jump over to the live chat. So I've read through the live chat. I, as many of you, have often used a live chat in my own customer service experiences. It can be good. It can be a very good outcome, and it can be a really awful outcome depending on whether you're talking to a human or a bot. Sounds like you're staffing the live chat with humans. Is that right? Yes, nodding. Okay. So I guess my question for you is, you called this a pilot. Can you kind of talk about what your plan is for the funding? So I understand it's $950,000 upfront to get it launched. And then annually, there would be continued expenses related to staffing, et cetera. So I'll give you my understanding of it. Your proposal here is that you would use $500,000 of the telephone penalty toward the live chat. And then the remainder would be from shareholders. Am I getting that right?
Mr. Martin?
Thanks, Chair Sullivan, Commissioner Partridge. I want to, I'll answer just that first part, but then I really want to defer this one to Ms. Howard because she knows the live chat program much better than I do. Our proposal initially was to increase staffing, the number of agents working on live chat, and that's where that 950K number came in. In reply comments, we sort of pared that back and proposed instead to use existing levels of staffing so that it would actually fit within sort of a 500K a year budget. So our proposal was to have that come for the first year from the penalty. But as to your other questions, I think Ms. Howard is probably better able to answer.
Okay.
Ms. Howard?
Actually, Commissioners, I think my colleague, Adam Bernowski, would be best to answer that. This definitely falls in his area of expertise.
Mr. Bernowski? Does Mr. Collin want to crack at it when you're done? We can go around the bases.
All right. I was wondering where this was going to stop. Yes, great question. So is the question related to the pilot phase? I just want to make sure I got clarification on what you're asking.
Chair Sullivan, I don't know that I know. I think, explain to me how you envision it working in the different funding streams.
Yeah. So this would be part of our contact center operations maintenance budget.
Okay.
So kind of a normal labor budget. We would look to increase the number of staffing. So rather than pulling it away from the phone, we would just dedicate some of our hiring towards that to make sure that we have sufficient staffing to the workload. So just like phone response, there wasn't an extended wait time to get connected.
And I'm assuming that, and I should have done this, but if I go on to your website, I see an option to do, I need help. This is one of the options I have to contact. Is that correct?
Correct.
And are you seeing customers use this option on a regular basis? You know, what's the uptake for customers?
Yeah, it definitely is increasing. So every month that goes by, we're seeing more and more. And some of that's a factor of how we advertise it. so to speak, on which pages of our website, mobile app. I mean, there's a lot of ways to kind of push this out there. So we've been very conservative to make sure we can keep the wait times at a minimum. But the overall response from customers has been overwhelmingly positive. Very high customer satisfaction connecting to a live agent. So we think it's a good thing to continue for our customers.
Thanks. Okay.
You also asked if shareholders would be
Oh,
paying
yes.
for that?
I think I had, in my reading of it, I thought that shareholders were kicking in some portion of the funding, but it sounds like that's not. I maybe misread that, or maybe I just believed that.
I'm not aware of that.
Okay.
Partridge, I think that what we meant to say there was simply that if the commission approved use of the penalty toward live chat, that would be coming from shareholders.
I see. Thank you for clarifying. Okay. My next question for you, and I will say, I understand and would like to hear from parties the concerns around live chat, because I understand there are some concerns. I would also say that my general sense is that the more options customers have to communicate and reach out to a company, the better. And if one isn't being used, then that's certainly a reason to say this is not a useful thing. But I'll just put that out there, that in general, I think the more ways you can communicate with any company, but especially a company that provides such an essential service, can be beneficial. So I'll get your thoughts on that, maybe real quick, and then one more back to the company.
Mr. Shardlow.
Thank you, Commissioner Partridge. I think everything you said is valid. In this context, you know, as you alluded to, it seems like issues with disconnections are driving complaints. And so in my mind, that suggests it likely plays into call volume as well. And if I have any reticence about this issue, is that I don't know who's using the live chat from an equity perspective. If that's a higher income person who is working from home, sitting at a desktop, is that who's using it? Or is it truly a lower income person who's in crisis? I mean, I guess you could say that if the live chat reduces, sort of redirects call volumes, maybe that allows the company to respond to the remaining calls more quickly. But I think in the spirit of, you know, again, like I say, in our Power On program, we still receive something like 75 faxes a week with applications coming in. So I think, again, just some reticence about what this was trying to remedy and who that solution would be for was what gave me reticence.
Mr. Cherney.
Thank you, commissioners. So for us, the biggest concern is from a rates perspective. Our understanding is that the live chat is currently being developed by Xcel through their, it sounds like, O&M budget. It's also not clear if there is a capital component to the technology that's involved in live chat. In any case, they've got their budget. Sorry, I'll get that. So that, you know, they've budgeted things out, and it goes into rates that way. The payment, the underperformance penalty that comes from shareholders would essentially be, it sounds like, taking from one account and putting it back into its own accounts in a different place. So the money just never leaves the company. It doesn't end up funding that because that was already funded through the budget that they put forth in the rate case.
Dr. Lieb.
Commissioners Sullivan and Partridge, I think that my colleagues or partners here have said most of what we would say. We'll just add, we have a concern that this one-time $500,000 infusion is not going to cover any ongoing costs for the live chat. So it's unclear what value it's really going to provide. But I think the larger concern is what Mr. Journey just pointed out, which is that these penalties are supposed to be punitive. They're not supposed to be just moving money around on O&M inside of the company. So if the company feels the live chat is an important thing to invest their O&M in, then it should be in a rate case and analyzed there. It shouldn't just be a transfer of money that is really supposed to be coming out of shareholders for having poor service quality.
Ms. Carroll, I think she wanted to.
Oh, thank you.
I might just flag one additional note, which came out in staff's briefing papers, and it came from the CAO mentioning that Xcel currently doesn't make those transcripts available for CAO to review. So if there are any issues between customers and representatives, at least making those accessible would be one piece we would certainly ask for.
Thank you, and thanks for seeing that. That is a great point that I did note. First of all, I think that's a really important point, especially if you are, it's one thing if you've got somebody asking, a clarifying question. It's different if somebody is using the live chat to talk through payment arrangements or something of that matter. So I do think the fact that it's not saving the transcripts could be problematic, and I wonder if there's a way for you to look into whether you could be maintaining the live chat transcripts.
Mr. Conlon.
Thank you, Mr. Chair. Commissioner Partridge, and I would defer to Deidre Howard if there's more to this, but based on what my understanding is we can make those transcripts available. Ms. Howard, do you have any correction there to that information?
Ms. Howard.
I'm again going to defer to my colleague, Adam Bernofsky, because he is the one that I think has rectified this issue.
I think she's used up all her photo friends by now.
Mr. Bernofsky.
We're getting pretty close. The availability of the transcripts, we have found a way to be able to pull those specific. So if there's a specific chat discussion transcript that we need to pull, we can get that now. We have figured that out.
And my final question on this matter actually goes to what Mr. Cherney brought up, which is, what would you do with your live chat program if we did not allow for the use of this penalty to go toward it?
Mr. Bernofsky.
It would basically slow down the deployment, the full deployment, adding resources. I mean, I think to the points made, I think we could still do it. I think it's just going to be slower to grow and expand and make available to customers.
So stating this as I think pulling in the comments we had from the department and the OAG, what you're saying is, yes, there is some base level funding included in your O&M budget to roll out the live chat. Additional money would allow for you to expand upon that current plan. I see.
Yep, correct.
Okay. Finally, I guess I just wanted to move on to the decision option that I put into the record and just make a couple statements about it. I saw that Commissioner Tuma also put in a decision option, and I would say, in my opinion, just reading it, not yet hearing from him, I think we're both kind of going in a similar direction on a slightly different path. I think from my perspective, this is a 22-year-old settlement agreement, and I think there are legitimate questions about the Commission's authority to modify a settlement agreement, especially one that has been established for this long without all the parties coming to us with a plan. I'm sure the other commissioners who were here for the last hearing last year on this matter will have questions about what happened with the stakeholder process that was ordered last year. But I think from my perspective, trying to work with this old settlement to try to solve a new problem is not likely to be successful. And so what I was doing with my proposed decision option is trying to find a way for us to kind of start fresh using the same metrics and perhaps finding a different incentive/penalty framework or structure going forward based on our authority under the multi-year rate plan to consider performance incentive metrics and to build in incentives through that process. So I'll just throw that out there. I think, not speaking for him, but I think Commissioner Tuma and I are kind of on the same path in that sense, but I just wanted to speak to that before saying I'm done.
All right, thank you, Commissioner Partridge. I appreciate the line of questions that you went down there. Commissioner Tuma.
Yeah, I appreciate that. I think we are, I actually like the tack that you're taking, and I'll start with Shardlow because I was trying to build off of your decision option as far as next steps. And I'll be honest, I went back and looked at last year's tape and looked at the old record. I don't know, I walked away, maybe I was clueless, feeling like, oh, this is a one-time bump. When you look at the numbers on page 5, I thought that 759 was shocking to us then, and we thought, oh my goodness, this is awful, and I felt like I was getting reassurances that this is, an anomaly and that things will get better, and then I come this year and it's double that. So, I mean, that was a little bit of a slap in the face back then as I watched the conversations. Maybe I missed something. That's never happened before in my life, but I'm joking. But Mr. Shardlow, I walked away from that meeting, and it was Commissioner Sullivan who pushed putting together a stakeholder engagement and process, and hoping that we could come up with something more meaningful, because we know one thing we certainly learned from doing this for a while is that we try to create it up here at the bench. It never is good as when we trust you guys to work on it closely and carefully. So I looked at how Commissioner Partridge has been developing a new docket using the performance-based incentives that we have authority in under the multi-year rate plan. That seems to give us some more direction, okay? And it's a new docket. I guess if I were Xcel, I would probably put a stakeholder group together to inform that docket if they were smart. But I'm kind of liking where she's going, and I was trying to build off of yours, so I'm kind of want to get your thoughts, and I'll ask the other advocates as far as next steps to try to get this into a place where it's manageable and something new that we could actually work with. So I kind of like where she's going, but you tell me if you would rather have it just be a stakeholder group as opposed to trying to tap into the performance-based metrics.
Mr. Shardlow.
Thank you, Commissioner Tuma. This is one of those moments where I realize I probably should have gone to law school, but I'll pretend.
Forget it.
Yeah.
At this moment, having been to law school.
You're doing better. You're doing better than any of us.
Yeah. I'll just start by saying that I have been involved in limited conversations about this in the previous year, and not to jump to the decision options, but if the commission goes this way, the OAG has offered the suggestion of more of a mediation with the Court of Administrative Hearings, and there was a nuance here that was not on my radar, the fact that there was a formal settlement. My understanding is that there are concerns that those conversations need to be limited to the actual parties of the settlement in a more structured arrangement, and I'll let other parties speak to that more articulately.
Yeah, I mean, I think where Commissioner Partridge is going is let's leave the settlement. I was too. Let's leave the settlement behind. I was just trying to put some pressure. I was trying to bring a hammer referral to the OAG, and let's get your act together, meet with these people, and hopefully in a year you'll have it figured out. But I'm kind of liking the track that Commissioner Partridge is suggesting, is that we, again, let's move away from the settlement. Let's come up with something new within our authority. And I kind of like the performance-based metrics as being an avenue that we really haven't used effectively out of the multi-year rate case statute. And so OAG. I mean, I don't mind sending it to arbitration, but I in some ways, opening a new docket and say, let's go this way, seems to me has the chance of being more productive in a year's time than this year has been.
Mr. Cherney.
Thank you, commissioners. So, I actually think that you do have authority and that this does not flow directly from the settlement, because the way that those settlement, they're not really full settlement agreements. Ultimately, it was the commission ordering Xcel to file a tariff that included a penalty. And in 2013, when things were redone, that also was not a settlement. There wasn't ever an actual settlement agreement. It was Xcel and OAG and the department negotiating, and then ultimately Xcel filing a tariff and saying, the other parties don't have an opposition to this proposal for the tariff. So really, we feel that this does flow from your authority, and it's something that you don't necessarily need agreement from the parties on. And I think that's also reflected in how Xcel, this notice of comment period came about because of the annual report, but also Xcel said they wanted a unilateral change to the complaint threshold and the definition of complaint. And so, by the same token, we're like, well, we actually think it should go the other direction, and we think that you have the authority to do that. If you didn't want to go that route, we suggested mediation at CAH because they are they know how to mediate, and I think that I also don't necessarily think that would need to be limited just to the parties to that original settlement, again, because it's not really, this doesn't really flow from any settlement agreement. It flows from prior commission orders. So that mediation would be, the parties trying to come to some sort of agreement on what makes sense going forward.
Yeah, I mean, that's good analysis. I appreciate that. The settlement had allowed us in the past to be more flexible with how we deal with the penalties. If we just follow the statute on the penalties, it's pretty limited. We send you off to the court and you sue them, and $1,000 goes to the legislature to throw down some place that we don't want it to go. And so we have a little bit more authority, of what to do here. And so I think that's why we've been gravitating towards the settlement, because Xcel has agreed to do something beyond what our enforcement authority is. Performance-based, though, is we haven't really explored that. I mean, it does have some elements. They've fought it and continue to fight performance initiatives for years. That's the struggle that I have. But that's a helpful analysis as I think about it, because we do I think where I'm seeing uniformity with Commissioner Partridge is that we want to move away from the settlement. The settlement really is not serving us well at this stage, and we need to reimagine what that looks like, and it doesn't seem to be doing what we need it to do. And so I think we agree with you there. I think we need it, but I don't know if sending it to CAH to work on it makes sense. I mean, I think we would look to you to do it, but that's, a lot of the pain and headache is going to fall on you and the department, Ms. Lieb and Mr. Cherney. So where are you guys at as far as how to move forward?
Dr. Lieb.
Commissioner Sullivan, Commissioner Tuma, the department agrees with the OAG on their legal analysis of your authority. In the event that you don't want to make the decisions today, though, we agree moving to a mediator rather than a stakeholder process that may not be able to find consensus is a better pathway forward. On the performance-based rate-making piece, we remember having the last time we tried to do this. So we appreciate Commissioner Partridge really creating a new clean docket and tightening very clearly what would and would not be considered there. The only thing we would want to add if we choose to go that route is that this is a performance-based metric for the utility to do what it should be doing as a matter of appropriate business. It's not something above and beyond what we would normally expect. It's just asking them to meet appropriate service quality metrics. So in that case, we wouldn't want them to receive an additional shareholder incentive for simply doing what they should be doing. So if we're going to embark on a performance-based rate making, we would need to lower the company's ROE and allow the performance-based rate making structure to allow them to make up the difference between where it's currently authorized and where it's being set at the lower level.
Hence the problem that we have had with performance-based, because they scream penalty and we scream incentive, and we sit there and get nowhere. Mr. Cherney, you had one added.
Yeah, thank you. So just one other option, if the commission doesn't want to order it in a tariff today, would be, and I have physical copies of this idea, it would be ordering us to mediation, seeing if we can work something out, because prior to this hearing, the parties weren't able to reach agreement, in part because it wasn't entirely clear what the commission wanted. Now I think the discussion has made clear a little bit more, and so, you know, it's for the law school folks bargaining in the shadow of the law, you know, now that we know where the commission's at, mediation could be a good thing. And then if we don't reach an agreement by a certain point and we bring you a settlement, then you could at that point send it to a new docket for the multi-year rate plan. That's another possible.
Commissioner Partridge, I had a follow-up too on that, but Commissioner Partridge.
I just wanted to clarify something that the department said, that if you read the decision option, it says one of the things that needs to be discussed is whether the department's own 3-tier penalty structure is an appropriate starting point. As this reads, it is not intended to provide additive incentives for performance. It's my understanding of an incentive is it can be negative, it can be positive. And in this case, I agree with you that it is a privilege to have an exclusive territory. Part of that privilege is customer service, customer satisfaction, and adequate service. And so it is the bar. And so this is more, there would be no, in my mind at this point, although I'm sure there will be advocacy to the opposite, and I will fully consider that. But in my mind, this would not develop incentives to be, bonuses for good behavior.
Thanks. That's a helpful clarification.
Do you mind if I, to Mr. Cherney's point, I've kind of been in the stakeholder group meeting camp, and that is maybe, it's obviously a little different spot. My feet aren't in concrete on it, but Mr. Cherney, wouldn't that argument that you just made about stakeholder meetings could be more productive if those meetings are also informed by where the commission is at, don't you think? It feels like it would be a lighter lift, a more informal lift.
So I think one of the biggest things about a stakeholder group, especially working on something that came out of a settlement, is that it does put the commission in a really weird legal position to be mediating a settlement when you're also the decision maker. So, for example, at CAH, when we have mediation in the rate cases, they have a different ALJ than the ALJ who's overseeing the rate case do the mediation. So it is just a little bit strange there. I also think, again, the mediators at CAH bring, there's some authority that they bring to the process also to sort of corral parties and keep the settlement going, that in a less formal process like the stakeholder group isn't necessarily there.
I guess I've just been thinking about this. I mean, we'll have the discussion more about the penalties are what they are and how they're allocated. I want to talk a little bit more about that. But I guess I would just like, it feels to me like Xcel has a pretty good signal now. It feels like there are more informal ways to get them to move. But I don't know. Again, my feet aren't in concrete.
I'm just curious, the path forward, I'm kind of,
Ms. Carroll.
I'm trying to understand a path forward. Mine aren't, feet aren't in concrete either, thankfully.
Thank you, Chair Sullivan and Commissioner Tuma. We echo most of the thoughts that other advocates have mentioned so far and agree that our initial preference is for a decision to be made based on the record that's been developed so far today and the decision options that are before the Commission. However, and we appreciate Commissioner Partridge's performance-based recommendation. One question we did have with it, though, was if, tying that then to a multi-year rate plan becomes an issue if at some point Xcel decides to not come in for an MYRP, and what would happen then to these metrics if that's the only hook that they're working with.
And I had a thought, and MJ, if you could just pass this around to the let me keep a couple for these guys. They probably want to see it too. Now, take it around. I want to ask you, the advocates around, and then I'll ask Xcel on what their answer is going to be. But I did have my new 25, which was intended to say, in addition to the settlement, we're going to start issuing penalties and try to create at least some incentive. My feeling, and I could be totally wrong on this, is that we had a good conversation a year ago and hit the C-suite up in Xcel and then didn't go anywhere. So I could be totally wrong on that. So I'll give you a chance to read this. It's an attempt to combine my new 25 with Commissioner Partridge's suggestion to do the new docket.
Is this the one that was in?
No, it's not any. It's all new. Drafted this morning. It's not all new. It's modifying my new one. Looks like Mr. Cherney's eyes are up, and so I'll start with you. My goal here was to create an additional hammer, or additional motivation, maybe is a better way to say it, in addition to the settlement, to say we're going to start tacking on $1,000 if you don't get a settlement by the next service quality report early 2027. We're just looking. So I don't know if this is a benefit to you. If it's not, I don't care. But
not entirely. Commissioner Tuma, I'm wondering first. I'm wondering just for clarification when it says each violation of the standards. The way that I read that is that it would just be a.
It reads this way: is every one over the number is $1,000. So
okay, you mean so every complaint over the.
So in other words, if we were to take this year's 1468, you minus out what the standard was, it's about $1 million.
I see. I think the way that I read this language, it would need to be. That would need to be made clearer because the way that I read it right now.
Pretty sure JD over here will make it clear.
Yeah. But the other thing is just that they're, like you said, one of the biggest drawbacks is that when we pursue penalties under 0.57, anything that is collected just goes to the general fund.
I'm hoping this never happens is my hope. My hope
Yeah.
it never happens. My hope is these people sit down with you and actually have a conversation. Now, I could be reading the room wrong. You could tell me if you felt that if the stakeholder process was productive and I'm missing something and that we just need to go in another direction, fine. I didn't feel like the way I read the record and saw what happened in the last years is like the stakeholder thing just didn't go anywhere. And it was partly because they didn't have to agree to anything. So I'm looking for some sort of motivation. If you don't think it's a motivator.
I mean, again, I think the strongest motivation would just be revising the tariff, according to some of the other decision options, like decision option 20. But I mean, one thought that I have is TUMA New 25 is also not necessarily, I mean, as you have here, it's not necessarily mutually exclusive with going with the MYRP route. It's also not necessarily mutually exclusive with trying to do mediation at CAH.
It is not.
So
It was meant to be, I was trying to make it fit within any approach, the additive.
I could see how it could fit with any approach. I think as it sounds like you're well aware, also just, trying to collect the penalty in district court creates a whole lot of other inefficiencies. So that's something to keep in mind, that, the tariff is something that you all are able to effectuate immediately with your order, and you get the penalty payment that goes wherever you order it to go right away, whereas going to district court, it's a court process, and all of the things that go with that.
Commissioner Partridge.
I have a couple things. First of all, I wanted to just lay out, and sorry I missed this earlier, but I wanted to lay out for all of us to consider kind of what I see the difference between mediation, stakeholder process, and a docket to be. And I think I'm a bit confused by Mr. Turney saying that we have authority, but we should use a mediator to go get a new settlement. Because if we have authority, why do we need a new settlement? Is that what you're saying, Mr. Turney?
Right. I don't think that we need to do a mediator or a stakeholder process
Okay.
at all.
You think we could just do it?
Exactly. If it's your opinion that as the commission that you need something else, then we would say mediator. But I don't think that we need that.
I understand. Okay, thank you. Okay, so then with that, I think from my perspective, I am not convinced that we do have authority to change the penalties within the settlement today. However, I am not an attorney. I would also say that I think I just want to put out the differences I see between having the stakeholders go either through a mediator or through a stakeholder process, work on something, versus a docket process. And I think it's obvious probably to you two very experienced commissioners, but the big difference is that we would get an opportunity to review the full record and all of the evidence and conversations that happened in support of various options that might come through a docket versus getting some sort of end result of a stakeholder agreement, or like happened last year, the stakeholder process kind of breaks down and we have nothing and we're back here doing this again. So I will say that. I would also say that it was brought to my attention that there are some ongoing related filings within the old performance-based rate-making docket. And so while I'm not pressuring anybody to move forward with that, if we did decide to go down that route, I would want to take a short break to see if I could work with staff to try to somehow fold those considerations into a new process. I just want to say this, and for those who have participated in the previous docket, and I can see Dr. Lieb is feeling exactly how I would be if I were in her shoes. It became so unwieldy and so large, and so my goal with this, with the idea, was to not let that happen. And so while I do recognize, based on what information I'm getting, that there are some related filings within that docket, I really want to cut this piece off and not, and allow that to move forward on a very efficient timeline so that we come back here next year and we already have this solved. And if we decide to go that route. So I just wanted to make that statement.
Can you just say that again? I'm sorry,
Which part?
one sentence ago, 2 sentences ago.
Anybody else remember? No. So what I was saying is that the previous docket got very large and, in my personal opinion, quite unwieldy. And I don't want for this conversation to be delayed or bogged down by the other docket. I want to kind of separate it, this very specific QSP issue, and allow for this piece to move forward efficiently so that when we come back, Commissioner Sullivan, make sure you're paying close attention. I'll forget it next time. So that when we come back here next year, we already have it solved and we have a path forward. We're not still, wading through a large docket process.
That's helpful, because that was when I read yours, I said, oh, I like this because we are narrowing down the service quality issue to this issue. And it doesn't have to be all the 7 or so metrics.
Right.
There's some metrics where I say, we don't need to study that, just let that be dealt with in the regular service quality report. But we really need to get down on this phone system, and we really need to get down on figuring out what's going on with these complaints and why they're happening. And we need to establish some clarity about that. I don't know if that's it. I want to give space for that to happen. And I tend to agree with you. I don't know how much authority I have with the structure we're in this case. And that's also why I liked where you're going, is because we're start opening a new docket and say go. And I don't think you have to, you can almost have your cake and eat it too here. You can still have a stakeholder process to make your docket go, and I think they would be wise to have that. I think that's why I think having that information, having the record being built, if the stakeholders doesn't go anywhere, we still are going to then work through our authority as much as we can to adopt some service quality standards through the performance-based metrics that makes sense. And I agree with you too that it should be penalties in this situation and not incentives like some people have been in, kind of bogged down the other service quality reports. So I think I've heard enough. Unless somebody wants to tell me, I'm comfortable. So
Can I just pack this into the old duder's head? Okay, so what we're saying is we would open up basically a service quality, a PBR docket on this. A new one. I think you would have to reference back, though, to the old one to remove that from that docket. But in parallel, we would be running a stakeholder group. Is that correct? And then you're sequencing them together. What happens if the stakeholder group helps to strike a new deal, the company is resolving them, what happens to the PBR docket then? Or would it just go poof? Would it go away, or what would we do with it?
Well, I think what I think you would do, so that this docket, I believe, is moving forward would be on a quicker time frame as I envision it. So you would take the results of this, and it would need to be informing whatever happens in the other docket. However, if there are relevant filings and information in, recent information entered into that docket, we'd probably need some way to get that into the new docket. So I'm not exactly sure how it would work, but I think I would need a little break to talk with staff about how to both expedite the new process and not mess up the old process, if that makes sense.
What if we get through the next 8 or 9 months and the company's resolved the problem? I think the service quality metrics are better. You know, the new programs are working, the new, chatbot or chat device is really, and like we see things trending in the right direction.
We
Do
high
we
five.
unplug it at that point, or do we know we will move forward with
I mean,
the PBR on this?
my hope would be that we would have something figured out and we could say, good job, high five, here it is if it starts to go downhill. Or we could decide we're not going to adopt something at that point. I mean, I think
It would just be
up
for
to us at
creating
that
the
point.
metric then, right? It wouldn't be actually for implementing, it would be just for creating the metric.
Right. I think in my vision, we'd come back here, we would have proposals for how an incentive, mechanism could work. We have a starting point, which is the department suggested a 3-tier penalty framework. And then we would have recommendations and advice from parties. We would consider that and decide if we want to adopt it at that point and what we would want to adopt.
What if Xcel came back and said, hey,
Fixed it all.
we have 2 complaints this year, we got it fixed, we got a great team, then I would be open to saying, okay, we were prepared, we were ready to deal with it if it didn't go the right way, but if we got it down to 2 complaints a year, hey, we don't need to do extra running around incentives if you've got this figured out, and we're confident they got it figured out. I'm not confident after I watched last year's hearing that they got it figured out yet, so.
Would I cut you
No,
off?
I
You're done?
think I'm comfortable. I think I know where my brain is at.
Okay, good. I want to hear from
A little hollow, but it's.
Xcel. What are you thinking?
Mr. Chair, appreciate the question, pardon me, and the opportunity to respond. I think we're generally open to stakeholder processes or what Commissioner Partridge you're proposing. I think it sounds like we'll take a break and see what that looks like on paper, but I think we're open to that generally. Commissioner Tuma, to your earlier line of questioning, if I may, I appreciate the discussion about authority to do so and not, and I think I understand the Commission's understanding of the nuance of the penalties and where such authority flows from or maybe does not. With regard to your new 25, I wanted to first appreciate the clarification that it's per instance. So that's helpful for us to understand. But then the second part there, and I just wanted to flag this, is the company probably can't agree to using that statute because as I read this, and I think the Commission had a discussion about this recently in a different proceeding, is there is language in there that it says knowing and intentionally. And it is not the company's position that we are knowingly and intentionally being the key word, missing these metrics. We are working to meet and achieve these goals each year, and the statute only allows for penalties under intentional violations, and it is the company's positions that we are not intentionally missing these metrics. So I just wanted to flag that.
Commissioner Tuma, are you still noodling on your modified new 25, or are you?
I'm open to doing my new 25, and the only thing is with Mr. Conlon would be is that I don't care what the statute says. The worst thing for you is to end up in district court, fighting over nuances. And so I think I have authority to create standards. That's why I put it there, assuming that you would never get there. So I would expect wiser brains at your C-suite to make decisions to go in the right direction and work with the stakeholders to figure out a better metric. And that's why I was kind of appreciative of the idea that Commissioner Partridge came up with, who is work with the incentives we have on the multi-year rate case. And so that has opened my mind. wasn't a lot there anyways, but it opened it up.
No, this is helpful for me too. Okay, we're going to take a break, but I want to ask a question.
Can I ask one quick clarifying question?
Absolutely.
On this, Commissioner Tuma, in this, with your new 25, am I correct in thinking it would be my new 25 plus your new 25?
I feel you could do both together,
Yeah.
yes.
Okay. That's it.
Okay, I want to go to the use of the allocation of the fines. I will just say, I think the $1 million, I know Xcel, I appreciate your proposal to split, the complaint 500,000 in both cases. But from my perspective, I think that $1 million should just go back to, help folks who are past due. And so I would take that million, the full million, and then, send that out to the, bill credits of $500 to not 1,000 people, but to 2,000 people. And I would do that both for, decision options. I would do that for, I think that's decision option 3, but then I would also do that with the telephone. And I'd be interested in hearing anybody's response to that, but I can make that. I could also, if my colleagues have a problem with that, I'd be interested in, pardon? Decision options 7 and 8 on the telephone response time. I just take that and use the full $1 million there for bill credits for 2,000 people for $500 bill credits, but that's my view. I can't imagine anybody would oppose it.
When I was in the legislature, I had to lobby for the constitutional amendment for outdoors, clean lakes and rivers and streams. That's what we always make sure, your lake, river, and stream. And the one thing they were always fighting against was backfilling. Mm-hmm. This worry that we're going to go and get this, $100 million, and all of a sudden the DNR budget from the general fund goes down $100 million.
Yeah, I remember that. Yeah,
we've done nothing good.
Yep.
And so when I read what Xcel wanted to do with it, my natural inclination was they're just backfilling. So it's all good stuff. It sounds good, but it's in the end they should be doing that anyways, and that's something they should build in the rate case if they're going to do a live chat, and then we deal with it from there.
Well, my view is the highest and best use of that penalty money is to help people out who need the help. So that's what I want to do. But if anybody wants to say anything, feel free. I see the shrugs of, yeah. Absolutely.
Sorry, my mic isn't on. I actually was wondering if you would look at number 4. So instead of number 3, it uses the full $1 million toward balances greater than 1,000. And then I was looking at B, so starting with the oldest to newest. So it's very similar.
Yep.
I don't know that there's a huge difference, and I honestly don't know how much that changes things. But
honestly, if there's a better way to use it, I just thought, right now it's pegged at 1,000 customers. Why not move that to 2,000, going, from oldest to newest balance? That was my thinking. But if somebody has a thought on a better approach to how to allocate the money, I'm open to that. Ms. Carroll?
Thank you, Chair Sullivan. Commissioner Partridge. Yeah, to Commissioner Partridge's point, the difference between decision option 3 and 4 is really at the eligibility of customers. So 4 was our proposal to decrease the past due balance that would make a customer eligible to receive that credit from $2,000 past due to $1,000 past due. And that was only because in previous proceedings, we recognize that Xcel has mentioned that there might not just be enough customers for that full disbursement if you're increasing it to the $1 million to fulfill that. So it would just account for that.
Great.
Sounds good. I think we're going to take a quick break. How long do people need? 10 minutes? Ms. McShane, 10 minutes? Okay. Okay, we will be back at 1:25.
Welcome to WebEx. Press 1. This webinar is being recorded and summarized.
All right, we are back, and sorry for folks who are online that you can no longer see us. We're having some technical problems with the cameras. All right, I think we're back. We've talked to staff. Who wants to go first? Commissioner Partridge.
I'm ready for a decision option, but
Yeah, I have 2 questions just to confirm a potential motion. So I just wanted to check with both the company and the settling parties about decision options related to the disbursement of funds. So first, and I think we noted this before going to break, so we probably are ready for this, hopefully. Is everyone comfortable with 4B, particularly the settling parties, the idea of giving the full $1 million penalty amount associated with customer complaints toward past due balances greater than $1,000 to those who have not otherwise received energy assistance, have received a disconnection notice, and made a payment on their account in the last 90 days, and then B, in order of oldest to newest.
Commissioners, the department supports that decision option.
Commissioner Partridge? Oh, sorry.
Commissioners were also okay with that.
Xcel?
Commissioner Partridge, we're fine with that. Our preference was largest to smallest, which is not actually what's reflected here. This is up to the commission, of course. If you choose the largest to smallest, you're giving arrearage help to the people who have the largest balance versus the oldest. And we can actually do it either way. There's arguments for either, but we're fine with either of those, 4A or 4B.
Does anyone have strong preference? Because I certainly don't.
I thought Cub was largest to smallest, right?
Thank you, Commissioner Sullivan. We're flexible. We had initially proposed, I believe, largest to smallest in our initial comments, but, or we had proposed one, and now I'm not as sure looking at these, but Xcel had expressed a preference for the other in reply comments, and we were comfortable with either.
Okay, so Xcel, your preference is A?
That's right. That's in our reply comments. We said 4A would be our preference.
Sorry about that. Okay, and everyone feels comfortable with 4A? Nodding? Great.
Commissioner Partridge?
Yes.
With regard to decision option 4, too, the decision option, as I read it, is internally inconsistent.
Okay.
If you use the entire $1 million for $500 bill credits for 1,000 people, $500 bill credits for 1,000 people is $500,000. So that's why I think we should do $500 bill credits for 2,000 customers.
Thank you. Very good catch. See.
They do teach math in Milwaukee.
Thank you.
I'm going to say that. It's my hometown. Another slight.
Option.
Sorry, I've got too many pieces of paper. Not enough organization.
We'll have to make that same correction on decision options, I don't know what you're planning to move forward, but when we get to the telephone one.
Okay. Mr. Davis, you caught that? Awesome. And then my next question, as Commissioner Sullivan caught for us, is related to decision option number 7, again, to see if settling parties are comfortable with that, and then with the note that we would change that to 2,000 customers as well.
Commissioner Partridge, we're comfortable with that. I just wanted to flag something about the mechanics, because now we're getting to, it'll be 4,000 customers that would have to meet these criteria, $500 bill credits to 4,000 customers.
Sure.
And so the reason this is a little hard to predict is because all of those criteria change on a daily basis.
Sure.
So last year, we started with one past due balance threshold. We didn't have enough customers, so we had to come back to the commission and propose a lower past due balance threshold in order to get up to the number of customers that we were aiming for last year. So now we'd be aiming for 4,000 customers. It might be that a past due balance greater than 2,000 works, and we can find 4,000 people, but we might, I don't know that for sure, and we might end up having to drop that further once you're getting to 4,000.
Good flag. Chair Sullivan, I think Ms. Carroll brought this up, and if we change that to $1,000, balance of 1,000 or greater, would that make that math more likely to work? Mr. Martin?
I think it would. I don't know.
Sure.
Like at
Yep.
the time, at the trigger date, I don't know what that number would be. I think, if you set it to $1,000, as long as we can find more than 4,000 people, then we just, and we're ranking from largest to smallest, then we're fine. And if we can't, we might just have to make a filing to you and propose something different. But I think that would work, but I'm flying blind on the data.
Couldn't you kind of make that self-executing though, that kind of tiering within the decision option?
Yes, I think so. On the fly?
Yeah.
Mr. Davis, can you help us here? Okay, so could we say,
If we do both largest to smallest, it really kind of takes care of itself, because it could be,
right, and then take out the threshold?
just lower the threshold real low, like
Right.
500 or something like that. and
Perfect.
It kind of takes care of itself, because you just don't get to the
Good point.
smaller ones.
Thank you, Commissioner Tuma. Let's do that. We'll just,
I don't understand.
so you just say largest to smallest. So if you've got a customer with $5,000, past due,
Start largest.
start with them, and you keep going until you
Run
are
out at
out of money.
$700, but
Got it. Okay.
Mr. Davis, you think you can?
they both need to be that way though, so.
Commissioner Partridge, are you wanting to just remove this $2,000
Yes.
threshold?
Yes, I think that's right. So we'd take out who have a past due balance, then we'd take out greater than $2,000, just take that whole thing out, and then your additional language in order of largest to smallest
Yep, we got it.
There we go.
would work. And that avoids any confusion and avoids Xcel having to come back and ask for permission to do something that we didn't think about.
Nice.
Okay. And then I will just, I guess, preview for commissioners that I'm thinking my new 25 with a slight modification, Mr. Davis has that, to reflect the fact that we have very similar and overlapping metrics currently in Docket 17401. While I want this to be fully separate from that, at some point, if we do decide to pursue Docket 17401, we don't want to have duplication. So the idea here is that once we do come back to Docket 17401, we would, at that point, determine where to put those metrics and not have duplication in these two dockets.
Okay. Commissioner Partridge, before we do this, I feel like I missed, we talked about decision options 1, 4. Did you do 7 as well?
Yes, we talked, yeah, we
Okay.
just revised 7.
And then after that, we are now moving into the decision options that you and Commissioner Tuma have submitted.
I have a couple more, and I guess I do want to get commissioners' thoughts on these.
Okay.
So there was some conversation in the docket about Xcel having some concern that wildfire mitigation activities could increase customer complaints. And the department had suggested that Xcel implement proactive customer education to communicate with customers about mitigation efforts related to wildfire management. It doesn't seem like a bad idea to start having some of those conversations with your customers. So I was thinking that we could order 11 and 12. However, it also doesn't seem all that relevant to this docket, if I'm being honest. So I'm open to either. Mr. Martin, looks like you might have a,
Oh, I just wanted to say we're fine with it. I mean, I think we would do this whether or not you order us to.
Sure.
Wildfire is even bigger issue in Colorado. So we've developed some of these materials. We think we can kind of modify them and no problem passing them by CAO. So.
Okay.
Commissioner Tuma? That's good. Okay.
And then the other one I do want to add in here is 16, offered by, I believe it was by Cub. There was quite a bit of discussion about the role of IVR, the automated voice recording. I don't think there's enough here yet for me personally to feel like I understand the role of IVR and whether it is helpful or not, and whether it should be included or excluded from the 20-second requirement. And so I did think that just gathering more information through reporting could be helpful for the next report.
Do you have that in?
It's 16A, B, C.
So your proposal would be to do 16A, B
Yes.
through C.
Yes. So it would provide us information about that 20-second call response with IVR included and without IVR included, so that we could better see the role of IVR and how it's affecting that metric.
Yeah, I think where we're going, it's a good idea to gather it. I was ready because I'm sick and tired of online trees, phone trees. So
Yeah.
that was the one thing I was ready to do. But I think given the direction we're going, that is something they can develop.
Right, if we can measure also how many customers end up screaming at the IVR, please give me a human.
Person, please.
Yeah, if there's any way to measure that, let's add that too.
0, 0, 0, 0.
It's funny how we all do the same thing.
Okay, so that's what I was thinking. And then Commissioner Tuma, I think I would look to you to see if you would like to include your modified new 25. I'm
comfortable going this direction. I would point out to Mr. Conlon, the statute actually says, as an or after the intentional, it says, who knowingly intentionally fails or neglects to obey. And so I think I could shoehorn an argument in there to get it on to the court. But I don't think at this stage I'm going to press that. I think they got the message. I'm tired of this coming back to us in this fashion. So.
Okay. So I can restate that.
Yes.
And then we can talk. Okay. So.
One none.
So my proposed motion would be 1, 4 as modified.
Or A.
A, yep. Perfect. 6. Wait, let me double check that. Oh, actually, yeah, I didn't bring that up. I should say Xcel 6 is a reporting requirement on your live chat function. Would you be willing to report on how your live chat function impacts telephone response time, even though we are not choosing to allocate penalty funding to it?
Yeah, we can definitely try to do that. Sometimes it's difficult to understand, like, would that customer have called or not?
Sure.
We don't specifically ask them in chat, but we can certainly attempt to make a correlation there to call volume. You bet.
How about we just make it easy and we just say require Xcel to report on the findings of its live chat pilot. Is that fine? Just to give us some information.
Yeah, that
Okay.
sounds good.
And then, so that'll be 6 modified, 11 as is, 12 as is.
That's 7. You want,
Oh, sorry. Oh, shoot. Let me start over.
Ken? I just was
Okay,
not tracking.
let me go back to 6. Oh, we'll go back to 6 and start there. Okay, then 7 as modified. Sorry about that, guys. Then 11 as is, 12 as is, 16, A through C, the additional reporting on IVR as is. Partridge, new 25, with that modified language about 17401. And then Partridge 26. And we didn't talk about that, but commissioners, that's just to try to reconcile the data in this with the open investigation on billing errors. And so I think that'll be most helpful for that other investigation.
Commissioner Partridge, with Mr. Davis, could you scroll it up a little bit? Wondering with the new 25, the way that I'm thinking about this is that this is going on in parallel with, the service quality, with what the company is doing right here. And it will create metrics that could be applied in the future. Would you want this to be an item that would be decided at, or that we would look to making a decision on in next year's service quality? Because from my perspective, if the company is, fixing the issues and we don't have, year 3 of this, I don't know if we necessarily have to do the PBR at that point. Mm-hmm. But I think it could be for lack of a better term, it's like a sword of Damocles, kind of like this is coming if this doesn't get fixed. Mm-hmm. That's actually a pretty good term for this. So
perfect.
It's me and my.
I was going to say a backup plan, but I think that, so we're allowing the executive secretary to set the schedule, but I do envision us hearing, hopefully having this decision happen at the time of the next QSP, because then we would understand, here's what they've come up with, but also here's the performance we're seeing, which would really help inform the need for this and what this might look like.
So it would be included in the next QSP then,
That's
right?
my vision.
We need to do
Should we say that?
an addition, or is that just now obvious?
Commissioners, I don't think it needs to be part of our decision option. You're just directing staff to schedule it at the same time, but if it makes you more comfortable, we can include language on that.
Why don't we do that? Because
I like having a timeline.
Yeah.
I think that's great.
Okay. All right. Well, once we have that, looks good, Mr. Davis. There we go. I'm supportive of your motion. I thanks to the parties for working with us here. Commissioner Tuma?
Yeah, no, I like it. I think it's a little bit more surgical. It's a smarter process to go as opposed to my battle axe. So,
Commissioners, could I make one
Yeah.
very small recommendation?
Mr. Cherney.
And thank you, Commissioner Sullivan.
It must be important because all three of you guys were like,
what did we miss?
So the Partridge New 25, the first paragraph of it says solely on improving Xcel Energy's electric customer service performance, but this is, the table includes gas, and of course Xcel's customer service is completely intertwined.
Yes.
So I would propose striking electric.
So as I understand it, Mr. Cherney, we only have authority under the multi-year rate plan, which is for their electric service.
So the multi-year rate plan statute says a utility operating under a multi-year rate plan. It's not a utility service. The definition of a utility or a public utility in .02 is it's about the company. So if there was an NSPM electric and NSPM gas, then that would be an issue. But the definition of utility operating under a multi-year rate plan is NSPM, which provides both services. It's the statute's not based on service.
Xcel?
The service is being provided.
Yeah, Xcel, I'd be interested to hear what you think.
Mr. Chair, appreciate the question. I think, haven't thought that through thoroughly yet, but I think our interest is having the discussion. And so if parties want to have a broader discussion sitting here right now on the fly, I don't think we're opposed to that.
Okay. Great.
So that would then be to strike electric and then just, correct, Mr.? Yep, okay.
Okay. Thank you. Uh-oh.
Uh-oh. Mr. Shardlow.
This will be very quick. Thank you, Mr. Chair. With the return of bill credits, just to make sure I understand, our intention would be to go through the exercise twice. To start at the oldest for the first penalty, giving 500, and then to do that again, so someone could.
Largest.
Sorry, yes, largest, but the person, the ratepayer with the largest could conceivably receive 1,000, correct? Is that the
Yes.
intent?
Yes.
Okay.
That is, I mean, sorry, 500.
500
It would
is the
be
maximum.
500 per customer unless, sorry.
But
Wouldn't that
aren't
be?
we doing the exercise
Hmm.
twice?
Mr. Martin?
I guess that wasn't my understanding, and if
I
the
see.
commission wanted to do that, we'd want direction on that. I thought we would, my rougher reading of this is we just have $2 million total to go toward arrearage forgiveness, and we're trying to go from largest to smallest.
Yeah.
We're not doing the process twice, unless
Yes.
Yes, that's my view. I mean,
Mr.
is there
Martin, that's what I was thinking.
some language that needs to be added that indicates like only one credit can go out per customer? Does that?
Sorry about that. That's a good question or a good flag. Yes, it was my intent that you get a max of 500 and you would go down to your, exactly as Mr. Martin said, you'd just take 2 million, you'd go down the list and you distribute $500 until you ran out of money from largest to smallest.
Yep.
that makes
Mr.
sense to
Shardlow,
me.
is that clear? Okay. All right.
Can I'm sorry to, I know you're trying to wrap up, and I'm sorry to bring up what's really a nit, but when Commissioner Partridge, and when you were talking about decision option 16, we are fine with 16A and B, no problem there. We actually already have the data for that reported in the SRSQ docket. But I want to give Mr. Bernowski a chance here. My understanding is we don't exactly have the data today for 16C, the way it's written, and maybe you can explain that.
Mr. Bernowski.
Yeah, we track, the calls that come in and the wait times, but we don't specifically have the data for every call above that 20-second threshold. It's kind of a yes, no. Did it meet the 20 seconds or not? Is it part of the 80%? There's ways that we could estimate and approximate to get close, but there isn't a specific number that we could provide.
Mr. Bernowski, so you don't know if it's not answered in 20 seconds, you don't know if the customer waited for 25 seconds or for 5 minutes?
We know in general like how long customers are waiting, but as just a standalone metric, like the other calls that were above 20, what was the exact average wait time for all of those calls? That's nothing that we pull reports on or even have the specific data. It's kind of put into different buckets of duration. So certain percentage are answered within 20 seconds, some between 21 and 30 seconds, others up to 45 seconds. So we can get buckets of time, but we don't have like the overall average. It's like with just stated, it's kind of a nit kind of thing.
Okay.
We just can't get the exact number the way it's written.
I think the data as you described it would still be useful. Would it be suitable to just say to the extent possible, and then you can give us data in some other form that gives us more information into that last category?
Yep, absolutely.
Okay, and I believe this was a CUB recommendation. Does that work for you, Ms. Carroll?
Thank you, Chair Sullivan, Commissioner Partridge. I think that sounds like it's what the company can do, so that makes sense.
Okay,
I'm ready.
don't look at anybody. Okay.
Heads down.
Don't look at anybody now.
All right,
Oh no.
Mr. Collin.
Sorry, apologies, Mr. Chair and
It's okay.
Commissioners.
Chair Sieben is not here today, so we're,
You're gonna be chopped down now. That's okay.
it's okay.
As a point of clarification, first question is Commissioner Tuma's new 25 in this motion?
No.
Okay.
No, it's not.
Thank you.
I'm glad you're still thinking about it, so that makes me happy.
Wait. All right, we're voting now. Commissioner Partridge. Is the motion clear to everybody?
Actually,
Mr. Dave?
I do, 4A was the motion, and I'm curious if 4B was intended largest to smallest
Oh, shoot.
instead of oldest to newest.
Yes.
The motion is now clear.
All right.
I really messed this one up, guys.
No, that's okay.
Here we go.
That's okay. All right. Commissioner Partridge.
I'm in favor. Yes.
Commissioner Tuma?
I am too.
I also vote yes. Thank you to the parties. And now we can move on to item number 2. Thank you, Ms. McShane. Thank you, Mr. Davis, Mr. Bowman. We appreciate your work on this, and thank you to the parties. All right. Mr. Bonet.
Otter Tail wants a multi-year rate case now.
Otter Tail. We're going to move into the next item. Can people hear me? All right, we are going to move into the next item here. All right. Mr. Bonet, if you would like to introduce the item.
Thank you, Chair Sullivan. Commissioners, good afternoon, Commissioners. Item number 2 on the December 4th, 2025 agenda meeting is docket number E-017/GR-25-359 in the matter of the application of Otter Tail Power Company for authority to increase rates for electric service in Minnesota. The issues before the Commission today are: should this filing be accepted, the proposed rates suspended, the matter referred to the Court of Administrative Hearings, and interim rates set as requested. Staff does have a few edits or corrections to the briefing papers. The first one is footnote number 44, which is found on page 19 of the briefing papers. The footnote intent is to reference the previous 2 footnotes on that page, footnotes 42 and 43, not footnotes 4 and 5, as is listed there. Staff apologizes for that. The second edit is staff tried to make all the corrections, understanding that the Office of Administrative Hearings changed their name to Court of Administrative Hearings August of last year, but one slipped through. So on page 41, which is in the decision options, that bold during the bottom says referral of this matter to office, it should be Court of Administrative Hearings. And the final edit is listed on decision option 20, which is found on page 44 and continue to 45. There are 2 subsection Ds listed. That first subsection D should be subsection C. With that, staff has no additional edits and is available to answer any questions the commissioners may have. Staff will note that the parties are available, are here, and have been informed that they will have opening comments. And so with that, staff turns it back.
All right, thank you. We will start first with opening comments from the company. Mr. Stephenson, I'm assuming that you will be taking the helm here, and then we will hear from the Department of, we'll hear from the Department, then we'll hear from the Office of the Attorney General, and then CUB. So, Mr. Stephenson.
Thank you, Chair Sullivan. Kerry Stephenson on behalf of Otter Power Company, and good afternoon, Chair Sullivan and Commissioners. With me today is Matt Olson, our Manager of Regulatory Strategy and Compliance and our rate case policy witness. And we appreciate the opportunity to address the Commission and thank staff for the thorough briefing papers that were prepared for today. And I'll identify our preferred decision options and then make a few comments about our application, focusing on the interim rates we seek to implement on January 1st. Our preferred decision options are 1, 5, 7, 8. We have no objection to decision option 9, which is tech assistance requested by the department.
Mr. Stephenson, on decision option 8, I've noted there's A through D. Are you just inclusive of A through D? Right. Okay. So 9.
9, and then finally 10, 11, 12, 17, 18, 19, 20, 21, and 23.
All right, great, thank you.
And with respect to our application, and especially interim rates, we think there's some critical context to keep in mind, in the context that underscores the reasonableness of our request. And first, it's been 5 years since we have filed a Minnesota rate case. And there has been a lot of changes during those 5 years. And we have made substantial and necessary investments in our system and in our people, and will continue to do so. But one thing that hasn't changed is that we had the lowest rates of Minnesota investor-owned utilities during that last rate case, and that remains true today through the latest data that is available. And for further perspective, even if we recover everything that we are seeking in our rate case, we will still have the lowest rates of Minnesota investor-owned utilities, and our rates will be dramatically below the national average. In fact, our rates are about more than 30% below the national average, whether on a residential or all rates basis. And for further perspective, the net effect of our requested increase, annualized over the 5 years since our last rate case, cumulatively is less than inflation over the same period. Again, this is important context, and we believe the interim rate increase should be viewed from this starting point. And we are, of course, concerned about the impact of interim rates on our customers, and that's why we have proposed targeted assistance to those most in need through our Uplift program. And if approved, we will increase the amount of bill assistance available to Uplift participants to help offset the interim rate increase. And that would be in effect through January through April of 26, the heating season. And we believe this is a better approach to addressing the challenges faced by low-income customers than the proposals put forward by others. For all of our customers, we are also proposing crediting back $2.8 million in excess balance in our energy adjustment rider. This would be reflected in an adjustment to rates starting on January 1st and then extending through April of 2026. And together, these efforts, we believe, are better suited to addressing concerns about affordability than the approaches suggested by the other parties. And those suggestions hinge on the Commission making a finding of exigent circumstances. And to be clear, the Commission has rarely found exigent circumstances. And when it has, the Commission's findings were supported by much more direct and much more compelling circumstances and factors than what has been asserted in this case. Those prior findings, those prior cases, involved the impact of the global COVID pandemic, or in the case of Minnesota's 2009 rate case, involved the Great Recession and its economic impacts, compounded by back-to-back pancaked rate increases and other unique factors. While we don't minimize the economic challenges some of our customers face, the situation today does not reach the level of exigent circumstances based on the Commission's past decisions. The claims that have been asserted in this docket are varied and general in nature. The federal shutdown, the 15th since 1980, is over. And for our most challenged customers, SNAP benefits are secured through at least September of 2026, and LIHEAP benefits are resuming. And we also ask the Commission to consider that we have voluntarily proposed to waive statutory timeframes and to suspend rates for an additional 3 months until February of 2027. And that is reflected in Decision Option 5. And the impact of inadequate interim rates, which result in permanent losses for the company, would be especially acute in this context. And therefore, we respectfully request the Commission to adopt our preferred decision options, and we look forward to your questions.
Thank you, Mr. Stephenson. All right, now we'll turn to the department. Mr. Adonisio.
Good morning, or excuse me, good afternoon, Chair Sullivan, Commissioners. Craig Adonisio for the Department of Commerce. I'll just run through our preferred decision options and offer a little commentary as necessary. For acceptance, we had flagged an issue in our initial comments, which the company subsequently addressed just a few days later. And so that issue is fully resolved. We appreciate the company's prompt action on that. So we support decision alternative number 1. On the suspension of proposed final rates, we support alternative 5. And again, we appreciate the company's flexibility on scheduling. For the referral for a contested case, we support 7, 8, and 9. And on 8, we are support all the subparts to the extent, though, that we could get any additional clarity on the concerns the Commission would like addressed with respect to Part D, either today or in the order. We would appreciate that. It's, I mean, we can run with it as it is, but it's just a little broad. For the effective date of interim rates, we support alternative 10, and we certainly don't oppose 11. I'm just not sure it's necessary. For the interim rate increase, we continue to believe that the Commission can and should find that exigent circumstances exist for the residential class. I understand certain things have changed since mid-November in the last few weeks. That the federal government has passed a budget that includes SNAP funding through next September, and that helps. But at the same time, just a couple days ago, the federal administration threatened to withhold SNAP funding for Minnesota and a few other states based on the state's unwillingness to provide personal data related to for the recipients of that funding. And so there's just kind of still a bit of a cloud over that. And then some of the other issues that we addressed in our initial comments, I think, still exist and are still causing just a general heightened level of uncertainty. And that includes a potential for another government shutdown in January and all the associated furloughs and layoffs and suspension of services associated with that. As we mentioned, inflation is ticking up again, and some commentators expect that to continue as the effects of tariffs wind their way through the economy. There's a general and significant concern about weakness in the labor market. As we highlighted, announced layoffs were at their highest levels in a couple decades. There's a weak jobs report yesterday. And then the last piece was the Affordable Care Act premiums, which the subsidies have not been renewed, and so that's going to be a significant hit to a lot of consumers. So we continue to support a finding of exigent circumstances, and our preferred decision alternative there is 15, and we would be supportive of combining 15 with the company's proposal for the increased uplift credits as well. And then we also support decision alternative 16. For the interim rates, capital structure and cost of capital, we support 17 and 18. And for the administrative and compliance issues, we are generally supportive of all of them, 19 through 23.
Mr. Adonisio, you had said with regard to decision option, I think you said with regard to 17, no, it was 16 that you appreciate was it the company's decision option 12? Did maybe I misheard something badly?
Chair Sullivan, we would support alternative 15.
15.
And if the commission wanted to, we would be supportive of combining our recommendation of a finding of exigent circumstances for the residential class with the company's proposed increase to the uplift.
The uplift program. Okay. Okay. Yeah. Thanks. Got it. Okay. Thank you. Right. Mr. Schultz.
Good afternoon, Commissioners. Peter Schultz with the Office of the Attorney General, Residential Utilities Division. I'm going to speak mostly, focus my remarks on the OAG's adjustment for a $3.2 million adjustment, which is not based on exigent circumstances. And I will address my decision options at the end. I'll tick through those after I give my initial remarks. So our initial comments demonstrated that the Commission should reduce Otter Tail's interim rate request by $3.2 million to remove a cost that is not part of Otter Tail's existing rates, specifically accelerated recovery of the Minnesota share of Coyote Station Power Plant. Under Minnesota law, as you know, interim rates cannot include expense items that are not the same in nature and kind as those allowed by a previous rate case order. The incremental depreciation expense for Coyote Station is a new type of depreciation expense that was not included in Otter Tail's last rate case. This new expense, as you know, relates to the Commission's recent IRP order, which contemplates that Minnesota ratepayers will no longer be served by or pay for Coyote Station after the year 2031. Otter Tail interprets the Commission's IRP order to require accelerated cost recovery from Minnesota ratepayers. But Otter Tail's interpretation has not yet been vetted, and it's not the only way to interpret the order, or even the most reasonable way. Notably, nothing in the Commission's order says anything about Otter Tail recovering incremental or accelerated depreciation. A reasonable interpretation of the order is that cost recovery, or that recovery of Coyote's depreciation expense should continue, as it always has, and that once 2032 rolls around, Otter Tail can recover the remaining depreciation at that time from North and South Dakota. And that last point is critical to understand, because there's been no indication that Coyote Station is going to retire before the end of its useful life, which is currently 2041. So after Minnesota exits the plant in 2031, the entire plant, the plant has 10 years left on its life at that point, and the entire plant can be used to serve North and South Dakota customers. This novel issue around Coyote Station should be fully litigated before Otter Tail includes the increased costs and rates. The early exit related depreciation is not the same in nature and kind as the depreciation currently reflected in rates, and the Commission should require Otter Tail to reduce its interim rates accordingly. Finally, the OAG, as noted in our reply comments, supports additional rate relief based on the exigent circumstances identified by the Department and by CUB. Upon finding exigent circumstances, the Commission has broad discretion to fashion rate relief in a way that it deems just and reasonable. And in this case, that could include either the Department or CUB's proposed adjustment or reduction. However, regardless of what the Commission decides in exigent circumstances, you should still make the OAG's $3.2 million adjustment to ensure that interim rates only include the same type of depreciation that is reflected in current rates. And I'll conclude by going through the decision options. The OAG supports 1 and 5, 7 through 11. And then on the interim rate increase options, 13 obviously reflects our $3.2 million exclusion. I just want to clarify that the $28.5 million amount listed at the end of that option is the most we would support, because we are open to the further reductions suggested by the Department and CUB for exigent circumstances. If the Commission doesn't find exigent circumstances, it could select 13 as written. As an alternative to 13, we would of course support 14 or 15 with the caveat that the final interim increase indicated there should also reflect our adjustment. And then we support 16 to file revised interim rate schedules. And then we support all the remaining decision options and all subparts 17 through 23.
Thank you, Mr. Schultz. Were you done? Okay. I just want to make sure I didn't cut you off. All right, Mr. Edstrom.
Thank you, Chair Sullivan and Commissioners. Brian Edstrom here on behalf of the Citizens Utility Board of Minnesota. Our recommendations remain as we articulated them in our written comments, and I'll use my time here just to talk about a couple of them. First, on exigent circumstances, we understand and we appreciate that exigent circumstances are, by their definition, meant to be the exception and not the norm, and that utilities and perhaps you all on the Commission are perhaps frustrated by the number of times that these types of arguments have been made in recent rate cases. But we do believe that there are extraordinary events that have been happening in recent years that warrant those arguments and warrant the Commission's consideration. Obviously, the global pandemic was a highly unusual situation. More recently, the longest federal shutdown in our history, coupled with the Trump administration's unprecedented disruptions of federal assistance programs, also has uniquely contributed to and exasperated a lingering affordability problem. And we view it as our job to help be a voice for those most vulnerable to these disruptions and to provide evidence of the affordability challenges that they face to inform the Commission's decision. We, of course, respect your authority and your judgment in determining whether those circumstances warrant a finding of exigent circumstances and lowering interim rates, but we would appreciate your considering those factors, and we believe that they do warrant that finding. Echoing what Mr. Adonisio said, we appreciate that Congress passed a continuing resolution that reopened the government after we filed our initial comments. That resolution funds the government through the end of January. However, the underlying partisan disagreement over healthcare subsidies remains. There's concern that the government could shut down again. I think more importantly and more directly, there's a growing concern that healthcare costs for Minnesotans and folks around the country will rise sharply beginning next month. We also understand that Governor Walz took action to at least temporarily restore SNAP benefits to eligible Minnesotans. But as Mr. Adonisio said, the Trump administration has renewed some of their challenges to SNAP funding just this week, and I think there continues to be uncertainty about that in the future. In their reply comments, Otter suggested we overgeneralize some of those concerns. But I do think that those concerns apply across the board, not just to folks in urban areas in Minnesota. I'll note that according to the Food Research and Action Center, the Minnesota county with the highest percentage of households participating in SNAP is Mahnomen County in Otter Tail service territory. 21% of households there rely on SNAP. And although Otter Tail hasn't filed a rate case in a while, the fairly significant rate increase here, coupled with that disruption in federal assistance, rising healthcare premiums, and other concerns about inflation and some of the issues the department mentioned, create a situation where there's risk of financial hardship that we believe warrant the Commission's attention. Second, I want to discuss CUB's petition to intervene. In their reply comments, Otter suggested CUB lacks experience working with and understanding Otter Tail's service territory. And I want to acknowledge that we have not participated in an Otter Tail rate case before, and that's true, but we have done a fair amount of outreach throughout the state of Minnesota, including in Otter Tail's service territory, and just some examples of that include last month we gave our outreach staff gave an all-day energy training to a community group in Crookston. We tabled at Fergus Falls Summerfest in June 2025, where our staff were there all weekend and talked to about 70 consumers. We are collaborating with the Air Source Heat Pump Uptake Project in Morris. We've received inquiries from around a dozen Otter Tail customers in recent years requesting our assistance with disconnections, arrearages, and other issues related to energy burden. And we pride ourselves on having an ear to the ground, on understanding some of the real issues that real Minnesotans are facing across the state. And I humbly but confidently believe that we've proven to the Commission that we're capable of intervening in complex cases like this one and providing unique insights, analyses, and evidence that assist you in making your decisions. So we reiterate our request that you grant our petition to intervene. And with that, our preferred decision options are 1, 5, 7, 8 inclusive, 9, 10, 11, 14 or 15, 16, 19, 20, 21, and 22. Thank you.
Thank you, Mr. Edstrom. Commissioner Partridge?
Chair Sullivan, Mr. Edstrom, could you go back to number 16 and then continue with your list of decision options that you support? I think it's the rest of them, but just clarify.
Yes, thank you, Commissioner Partridge. So let's see, after 16, 19,
Oh, okay.
20, 21, and 22.
Thank you.
Thank you. All right, we will start now with Commissioner questions. Commissioner Tuma.
Yeah, it's for Otter Tail. I was reading your filings, and I'm trying to get my head around a little bit of the impact to your ratepayers. And we talk about rates, and I appreciate that. Of course, bill impact is what we like to focus on, and so I struggled to find any clarity on the average monthly. I always kind of like to use average monthly for residents. I think it's usually your biggest class and gives us a sense of what's going on with it. You did in page 4 of your application note that the residential customers are going to experience approximately $18 a month from the increase. And I believe that's your overall increase, if I'm tracking with it. What would be the anticipated overall impact, do you know, for interim rates for residential customers?
Chair Sullivan, Commissioner Tuma, that would be $13.15 for a residential.
15?
13.15.
And what percent of the average bill is that, do you know? I see someone kind of cringing in the back, so I don't know if they can do the math. To somebody, we can go to another topic too if someone wants to calculate it.
What percentage of that $13.15 is part of the
average bill?
I think it's like
they're working on it, and you can interrupt me once they get it. I was going to, and I appreciate you pointing towards the inflation. I assume Minnesota CPI is what you used for determining that you're under inflation. I had about 19% for Minnesota, so I actually went and did the quick calculation off the internet. I burned some AI carbon credit someplace getting that, so I can't say that I know for sure that it's 19.5%, but it's in that ballpark. Is the inflationary increase over the 5 years that you would experience? And so I noted that even your at worst case scenario, what you're proposing would be above that, so we don't have to go through the math on that. I appreciate you pointing that out. Are the riders part of the interim rates? My understanding is they're not part of interim rates, but they come in at the end of the final rates. Is that my understanding? So the $13 increase is not inclusive of riders.
Mr. Stephenson. Oh.
Chair Sullivan, Commissioner Tuma, that is correct.
And that, I think that's important to know. The riders will come in, kind of a wash when it comes down to it. But as far as the ratepayer impacts, whatever the percentage increase is what they'll see on their bills. Any indication how much the average bill would be reduced with the rider refund that you have discussed from January to April?
On the energy adjustment rider,
Yes.
the 2.8 million excess balance we have, that's a credit that I think comes down to, is it 590 to 290? 290.
Okay. And my question would have been, what percent of the average residential bill would that be? I'm trying to get an understanding of what is facing your ratepayers when it comes to that issue. So during that month period. So if you could get those calculations, that would be great. And I can move on to something else once I've told them kind of what they seem to be. They got some numbers for you?
Mr. Olson? Oh.
Thank you, Chair Sullivan and Commissioner Tuma. I will probably wait till it's more precise instead of giving the off the cuff.
That's helpful. Let's talk about Coyote. Will they get the numbers? And, I asked you if interim rates were inclusive of riders, and the reason riders are not, because they're not like in kind. And I think that's the big argument that I'm hearing from our OAG. Thank you for catching that. That was very helpful. I appreciate gold star to everybody caught that in your office. But reason we don't include riders in the interim rates is because they're not like in kind. I mean, it's just they're not the same thing. And to me, that's what this change to depreciation looks almost exactly like a rider adjustment. How do you distinguish from the riders to include this now change of depreciation that was not anywhere approved by us? I went back, I read that orders very closely, and there was no approval of that. You're saying it is general accounting practice, okay? Well, that could be the case, but even if it is, even if I concede that to you, it's general accounting practice that you roll in your riders in your rates. And the reason we don't do it in interim rates is because they're not the same. So how are you distinguishing the advanced collection of depreciation from Coyote from your rider or interim rates?
Mr. Stephenson.
Chair Sullivan, Commissioner Tuma, I think it's depreciation. Any way you slice it, it is depreciation that we're seeking. And it is depreciation, and we believe we are following the Commission's order to immediately start taking steps to cease collecting the Minnesota allocation for Coyote Station.
Can I interrupt you?
That's not what I read in the order,
Yep.
so
Yep.
go ahead.
I was just going to interrupt, sorry.
But you can go ahead, because I agree with you, because I read it very closely, and that's not what
I read it. It says immediately in a reasonable and prudent fashion. That seems to me to require the development of a record and a deliberative process and a rate case.
And part of our rationale, Chair Sullivan and Commissioner Tuma, is that we are compelled by that order to cease recovery for Coyote Station by the end of 2031. And what we're concerned about is the time compression that occurs during this rate case. So if, for example, depreciation were to be accelerated to conclude recovery of that by 2031, if the order comes out in February of 27, now we're pinched. Our customers are pinched. And this is actually, we think, more advantageous for our customers and less risk, in the sense that if you reached a different conclusion during dependency of the rate case, it'll all be addressed in the interim rate refund.
Right, I get that, but that then goes back to the argument it's not like in kind. Your argument is expediency, exigent circumstances almost is what you're arguing. On the reverse side is that this will have a large impact, but we haven't made a determination that it should be collected from Minnesota ratepayers yet.
I think our view, Commissioner Tuma, is that it is depreciation in any way you look at it. There is the unique circumstance, but it doesn't change the fact that it remains depreciation. That's what we're collecting.
I get that, and I think that's what these guys are going to litigate with you, is whether that depreciation should be. Let's give an example. Let's say in Minnesota, we have a solar facility that North Dakota is paying for. It's in the rate base. They're paying depreciation. Okay? They missed it. And all their efforts, they didn't miss this a certain solar plant that they weren't aware of. And they find out about it in their next rate case. Okay? And they go, wait a minute, that's against our state policy. We found that out pretty harshly over the last few years with Hoot Lake, and we also experienced it with Geronimo with Xcel. Okay? And North Dakota says, wait a minute, we don't want to be taking energy from that. We want you to do the same thing you did with Hoot Lake. Okay? And make Minnesota take that over, and Minnesota ratepayers get all the benefit from it and pay all the cost. I got a bridge in Brooklyn that I think I'll sell you if you believe that North Dakota is going to sit there and say, oh, guess what? Well, we'll just keep paying the depreciation on that, okay? Because it's still used and useful in Minnesota. Minnesota should be paying the depreciation for that facility here on out, okay? And so I'm sitting here with a coal plant in North Dakota that will still be used and useful to the North Dakota and South Dakota ratepayers, that they're willing, from their policy, to continue to pay it. And so I'm struggling with how I would pay for that. I don't want to make that determination now, but I can, as I sit here today, I find that to be troublesome. And you have been setting up a scheme over the last few years, a good scheme. We've been working with you on it. Hoot Lake was the prime example. We're willing to try to find a way through this. But we're setting up parameters and creating policies on the fly. There's no specific policy. You rejected the concept of dividing up Otter Tail into two service companies, okay? And you want to keep it the same. I get that. You're small. There's a whole bunch of reasons for that. But this is pretty significant. We're setting a precedent on closing down a facility that will still be used and useful. And we haven't done that, to my knowledge, yet anywhere. And so this is the first instance of this question about whether we should be paying for ongoing depreciation for a facility used and useful. So help me out. I went back, read the orders very closely, and we didn't say we were going to stop and pay advanced, accelerated depreciation, okay? But maybe I'm missing something. Is there some plant that I missed out on that we authorized that we're going to continue to pay depreciation even though it's still used and useful for North Dakota and South Dakota?
Mr. Stephenson.
Chair Sullivan, Commissioner Tuma, I think from our perspective it would be, we're essentially being directed to cease utilizing an asset on behalf of Minnesota customers. And I know you said you don't necessarily accept this, but under general principles, yes, we would be entitled to recover depreciation for that asset. And we believe this is consistent, at least not inconsistent, with the parameters that the Commission has approved in the rate making for early retiring facilities.
Early retiring facilities. It's not early retiring. It's still going to be running. You're going to still have customers who apparently are willing to keep this plant running and pay for its depreciation share. And that's the big distinction here that we need to figure out. What should be the philosophy when we do shut down these plants? And I understand the kind of exigent circumstances of your pinched ratepayers, but I'm struggling with setting this as a precedent, particularly without a record. And interim rates too.
And Chair Sullivan, Commissioner Tuma, and you wouldn't necessarily be setting any precedent, as I indicated. This will be vetted out during the rate case. We believe this is same nature and kind. It is depreciation, any way you look at it. And again, you wouldn't be setting a precedent. What we have in our filing is that this will be put in a tracker account. Let's say we recover depreciation and interim rates, and in the rate case, it'll be in a tracker account. And then when the final disposition of Coyote Station comes, we're not looking for a windfall. We're certainly not looking for a windfall. If it turns out that those other jurisdictions or third parties or other co-owners would cover that item, then that'll be made right with Minnesota customers in subsequent filings. So you're not being boxed in. We're not trying to box the commission in on setting up, answering the question now. We recognize that it will be litigated through the rate case. But again, we believe it's same nature and kind, and it makes more sense from our perspective to not run the risk or to avoid the risk of having that pinch time frame to deal with.
So, Mr. Schultz, you heard their argument. They're worried about ratepayers getting pinched with the $2.8 million, and we're going to litigate this fully. Are you persuaded?
Mr. Chair, Commissioner Tuman, no. I don't want to reiterate all our arguments, but I want to respond to a couple points. So, Commission, I heard an argument about expediency. We fully plan to litigate this issue in the rate case. And I think there's other factors. I mean, there's going to be a lot of things that shift in the rate case. We don't know how this will impact final rates, whether it gets approved or not. But on the expediency issue, I mean, they didn't include early exit fees for the plant in interim rates. That would be more expedient, I suppose, to recover from ratepayers and not, create a higher collection and final rates, but they didn't do that. Basically, this is not normal depreciation. I mean, when I first looked at this, I'm like, I was thinking about it as like, this is an early retiring plant, but it's actually not an early retiring plant. It's not like Sherco 3 and King. And Otter Tail actually admits in its testimony that they can't treat this. This is not technically accelerated depreciation because the asset's useful life isn't changing. So we would submit that it is different in nature and kind than other depreciation. It's not normal depreciation and it's new. So nothing I heard persuades me that we missed something.
And I would encourage you to look. There is some precedent. There was a point where Wisconsin, I don't know the reasons why, but Wisconsin broke off Xcel, created Xcel Wisconsin and Xcel Minnesota, and North Dakota, South Dakota at the time. And they would have broke off facilities. I would be shocked and surprised if Wisconsin voluntarily decided to continue to pay depreciation on used and useful assets that are now Minnesota ratepayer assets. And I would be shocked and surprised if Minnesota ratepayers continue to pay for something that was in northern Michigan, or wherever Xcel Wisconsin had their plants. So I mean, I think to me that once you start doing this division of responsibilities, okay, and they're trying to do and set precedent, that's the part that really concerns me. And so I commend you for raising this issue. And it sounds like you would say, we'll gamble on the $2.8 million pinching ratepayers at this stage is what you would say.
Yeah, Commissioner Tuma, or Mr. Chair, Commissioner Tuma, I'm not clear on the 2.8. I missed for the 2.8 million.
No, maybe I could be picking the wrong number.
I thought the incremental amount was lower than that, but yeah, we I guess
3.2.
The litigation risk of that.
3.2. My apologies. 3.2.
3.2 is right. Is what we're savings. Yeah. Now,
and that would be the money that would be.
If we lose the issue, it's an extra
collected
million,
over
all else equal, but that not all else is not equal. So.
Right. And there's no indication that we would have to do that. I mean, say we would. I mean, shocks. I'm just one of the commissioners here. I tend to agree with your argument, as I said here today, but I want to wait for the full record. I don't see why I would have to say that you have to collect that in 2 years. You could collect it over a longer period of time if I wanted to have ratepayer mitigation. We've done that in wind farms. I think we probably did it in wind farms in your last rate case. If I could be mixing up with Xcel's and Minnesota Powers where we've done some of those ratepayer mitigations. So, well, that's all I have on Coyote. So I don't want to stop anybody else from asking questions on Coyote.
I guess like where I'm at with this is, and Mr. Stephenson, is you're asking us to make a prudency determination that this is an expense that should be recovered now. And I mean, I kind of agree with you. It's probably pretty likely that it's going to be determined prudent and recoverable, but like we don't have all that information yet. We don't have a record on that. Like to Commissioner Tuma's point, I mean, we can change the depreciation schedule. We can, if at that point in time we decide, yes, it is, and we could spread it out a little bit longer. I mean, I don't know. I mean, I'm kind of looking at the department here. I mean, it feels to me like we would be taking an issue potentially out of the rate case that the department would want to do forensic analysis on. But I don't know, Mr. Adenizio, if there's anything you want to weigh in on that.
Chair Sullivan, we certainly recognize that this is a complex issue and that there are, I think the OAG raised a lot of really good points. I guess where we ultimately came down is that, I guess I'm not an attorney, but I don't think including it, allowing this expense to be included in interim rates amounts to a decision on prudency. There's nothing about this will be a foregone conclusion for purposes of final rates. It will get the same treatment regardless from our, in terms of our analysis. So that's why we
kind of didn't weigh in on it. Okay.
Certainly recognize the OAG's point of view here.
I do have questions on another avenue, so I don't want to.
Can I just ask a clarifying question on this issue? So I understand what the company is saying, what the department is saying is if you include it, we will still fully develop this in the record and decide whether this is an appropriate strategy for the depreciation of Coyote. And what the OAG is saying is that may be, but we still don't think it should be included in interim rates. And I'm wondering if, Mr. Schultz, if you can tell me, and I should have caveated that, the reason you're not concerned, or you would fully develop it, and then it would be subject to a refund if you just, if the commission determined we shouldn't depreciate on that timeline. Mr. Schultz, can you tell me what the risk is if you put that into interim rates? Is there an additional risk, or is it more about that this is just simply something that is novel and has not been discussed, and so to make the presumption is a leap that we shouldn't be taking for interim rates?
Mr. Chair, Commissioner Partridge, I think it's more the latter. We don't believe it meets the criteria to be included in interim rates. Exigent circumstances aside, it just doesn't meet the criteria because it's new.
Okay.
And it's, especially if the commission were not to adjust rates for exigent circumstances, it provides some rate relief in the near term during the interim period.
Okay, thank you.
On the bill numbers, you have those yet, or?
Yep. Chair Sullivan and Commissioner Tuma, yes. So the average current bill for one of our customers with average usage would be $93.66, so just under $100, $93.66. The interim increase of $13.15 that Mr. Stephenson already spoke to would amount to a 14.04% impact. We're proposing the energy adjustment rider credit for those 4 months of 2.8. $2.90 was about that came out to be, and then that brings down the delta to 2.98%. That's an adjustment down to that. So
average bills for at least the first few months during the winter months will be about 13% increase, and but for the remainder of the rate case, somewhere about 14% on average bills. That's helpful, and that's in face of a 15-year inflation of over 19%. So, okay. Jurisdictional allocation. were the interim rates adjusted for any changes in jurisdictional allocation, or are you using the jurisdictional allocation from the last rate case? My understanding is supposed to be the last rate case. Is that what you have done for interim rates?
Welcome. If you could just introduce yourself for the record.
Thank you, Chair Sullivan. Pat Zomer on behalf of Otter. It reflects the same methodologies, but it reflects the test year billing determinants. So there's no change in methodology, but it does reflect the projected test year sales for 2026.
So there is some modification due to what I understand is going to be a higher allocator for North Dakota.
Chair Sullivan, Commissioner Tuma, that is correct. If we had maintained the same billing determinants from the 2021 test year from the last rate case, the increase would be larger for Minnesota customers. Right. So this reflects the fact that more
interim rates I'm talking about, not final rates.
Both, because we're using the test year billing determinants. So it does reflect the fact that during 2026, North Dakota is a larger share of the system.
So that's built into the test year. Okay. That's helpful. Okay. And where do you sit going into the rate case for what you're claiming are the jurisdictional allocators then? You know the number that you were using?
Chair Sullivan, Commissioner Tuma, there are several. The growth in North Dakota has been mostly in the energy side, kilowatt hour sales, not demand. So I'm going to turn around just a second. Chair Sullivan, Commissioner Tuma, in the 2026 test year, the energy allocators there's two different ones, but I'll just approximate. For Minnesota are, between 46 and 48%. For perspective, in the last rate case, those were 53 to 55%.
Okay. You probably would, based on the discussion you just had, would be okay if we had a decision option to modify A to include a thorough review of the jurisdictional allocators with South Dakota and North Dakota as being one of the major things we would send on to the ALJ for the rate case. No objection to that, I would assume.
Chair Sullivan, Commissioner Tuma, no.
I think that's a factor that we're looking at and trying to understand in greater detail. So I just have one other area, but I'm happy to wait.
I was just going to, my questions were, I was just going to go to exigent circumstances, but whatever you want to do.
Just really quick on the email matter to Cub, okay? The way I read the decision options is 23 and 22 are kind of ors, one or the other. And you had just some more details built into what you want to see in that email. You just don't want them to send out the notice that goes in the newspaper. You want something that looks more like an email, I guess, is what you're thinking. And I'm fine with that. I don't think it adds a lot. I just would curious of whether it would be okay with we put in there in consultation with CIO. So develop it with CIO. I mean, you had a list of things that kind of lay it out, but we have these experts that do this on a regular basis, and so just to you, Mr. Edstrom, if that's where we go, are you okay with that?
Yeah, Chair Sullivan, Commissioner Tuma, thank you. I think that's a great suggestion, and I saw those as kind of alternatives as well. And as far as sending an email to what Otter Tail has on file, I think that's a reasonable suggestion. And I think what was particularly important for us was, the information that we articulated in that decision option, but especially the link to being able to file a public comment. I think that's really in our experience reviewing Xcel's last electric rate case, has really increased the level of public participation and public comments, and just something that we think might be helpful moving forward in all utilities rate cases.
And so on 22, whether we do it or not, you're okay with we limit it to those customers that have emails on file?
Yes.
Does it say that in yours, or should it be added?
I don't.
This is my dyslexic brain. It can't read that big of a paragraph.
I don't believe that's in there, but I'm not opposed to that being added.
We can work on that. Those are all the questions I have.
Chair Sullivan,
Commissioner Partridge.
Can I ask a question about 22 before you
Absolutely.
move forward? So, or maybe this is more of a comment. One thing that when I read this, it seemed all very helpful. One thing that kind of was flagged in my mind is I just want to make sure that it is extremely clear, and this is for the company, that that customers understand that your descriptions are of your request and that this is not something that the commission has approved. I just want to make sure there's no confusion, because sometimes when you lay out details with this level of granularity about a requested ROE and bill impacts, it could easily be sort of perceived as being final. And so I just want to make sure that the company makes it overtly clear to everyone that this is a request with the commission, and perhaps you could include some information about the commission process. That's the one thing I thought would be useful in here that I didn't see, is just there is a process, you're going through the process, this is the request, and there will continue to be record development, which will help to elicit that engagement, Mr. Edstrom, to be really productive with the commission process.
Thank you, Commissioner Partridge. I think that's a really wise point. Good. I wanted to talk about exigent circumstances, and I wanted to pick up. I mean, Mr. Stephenson, you had made the point about the differences between this and COVID, and I do fundamentally agree with that. And I think that, I mean, my view on exigent circumstances is that it has to be extremely rare. And from when we were doing exigent circumstances, and I was just speaking for myself, but when we were doing exigent circumstances during COVID, we basically applied the same rationale to each of the utilities in reducing the residential rate increase. And the rationale for that, from my perspective, was, this is, it's a once in a century, let's hope, fingers crossed, it's a once in a century pandemic, and, everything that I don't need to go over right now, but it was that moment. And today's moment, I recognize the points that the OAG raises, that Mr. Edstrom and the department, support, but I think that, Otter Tail does have, like, as you said, some of the lowest rates in the country. We have, I recognize that there is an affordability, there are affordability challenges right now. I just don't think it rises to the level of exigent circumstances. So, which again is an extremely rare situation. From my perspective, if we were to do exigent circumstances in this particular instance, we'll just do it forever. I mean, in every case. And so that's where I'm at with exigent circumstances. Mr. Schultz, Mr. Edstrom, I mean, I've given you the opportunity to change my mind, but I just don't see, I don't particularly like this statute. I don't like that it's basically, your one out is this very gray, granular, in the eye of the beholder kind of, language, but I just don't see it in this instance. So if there's something I'm missing, I'll give you a shot to change me.
Mr. Chair, we supported the department's initial recommendation and Cub's recommendation to find exigent circumstances. I think they made the argument in this case a lot more cogently and eloquently than I can. In this particular case, I recognize we've argued it in the past.
I guess I look to you as the exigent circumstances guy, because you guys always raise it.
Yeah. Well.
and I appreciate the department is here, but they're kind of newcomers in the discussion, which is, I understand why. But
Yeah, I mean, I think the reasons stated in our reply comments, we think that the factors cited by both Cub and the department rise to the level of exigent circumstances. I mean, the commission has found, yes, during the pandemic, the commission found exigent circumstances. The commission has found exigent circumstances in many situations besides the pandemic. One of them being, in almost every Dakota electric rate case where the company says they don't need the full amount they would be entitled to under the statute. I know that's a different situation than this, but it's not an emergency. So I think there's a wider variety than just global pandemic where the commission has found exigent circumstances.
Okay. Mr. Edstrom.
Thank you, Chair Sullivan, for the additional opportunity to discuss this. And I guess just to reiterate what I said in my opening statement, I truly am cognizant of a lot of these arguments being made recently and how that can may be frustrating to the commission. But I'll say again, I think part of that is reflective of there being a lot of unusual circumstances that have been stacked on top of each other recently. And if you were to think about if the pandemic hadn't happened, would firing all the LIHEAP staff and the longest federal shutdown and trying to dismantle SNAP benefits, I mean, those are pretty significant things that have happened. And again, we're obviously here as ratepayer advocates. We have a perspective and a constituency that we're bringing, and we're trying to give you evidence to consider as you are the decision maker. So we respect your decision, but again, we just want to do all we can to help you protect ratepayers from financial burdens that they're likely experiencing right now.
Yeah. Thank you, Mr. Edstrom. I appreciate that. Okay, any additional questions? Commissioner Partridge.
I just have one note, which is what was a little bit new, I think, which I may be wrong about, is the wildfire grid modernization efforts that you discussed in here, and I'm hoping that you continue to develop that throughout the record. I think this is somewhat new for Minnesota, and we are trying to learn and get smart on what this can look like. So I do hope to find more information and hear about what you all are doing and what you've considered, et cetera. So that's it.
Do you want to take 5 to make a motion, or are you good?
I think I just have one adjustment. I think Mr. Graham and I will be able to make that without a problem. And I do have just copies of what was the decision options. He's going to put them up on the screen so you'll see them. They're essentially the decision options on the back of your briefing paper. So there's a few changes that are oral changes that we'll walk through as we go along. Starting, we start at the top if you could, Chad, and we'll go down from there. So I would move decision option 1, and then decision option 5, and then decision option 7 as presented. 8 is slightly modified, okay? And so all of the items that are in the briefing paper, but then I would add an E and F. And E is a thorough review of the jurisdictional allocators with South Dakota, North Dakota. And then F is whether the company's proposed assignment of undepreciated plant balance expense for Coyote Station exclusively to Minnesota ratepayers is just and reasonable. So we need to resolve that. I'll give my opinion on it later. I don't want to break up the decision option of opinions. The 9, 10, and 11, as in the briefing papers. And then 12, with a modification. I would approve, and then I would delete the company's proposed revenue deficiency for interim rates, but I would include and keep Otter Tail's proposal to increase the uplift credits that they proposed in their reply comments. And then I would do 13, which is the OAG's number with Coyote Station depreciation acceleration removed. And then I think if we do that, then we would have to do 16 because you'll have to file a new revenue deficiency amounts with us. And then I would do 17, 18, and then 19, all of the subparts, and then 20 with a very slight modification. When I printed these out, it didn't turn into two Ds, it turned into an extra A. So it is, the C is now the third thing there, so that's a modification, but it's just the changing of the numbers. And then for 21, I included the executive secretary's approval of the electronic notice. That's the term that Cub used for their email, so that would be also approved by the executive secretary. And then modify 22 to indicate that this will be drafted in consultation with CAO, and I think that would address some of the concerns that you had, Commissioner Partridge, because our CAO is going to make sure that language is drafted as best it can. So Otter Tail work with CAO following the basic outlines of the email. And then I would add then to that, Chad, a sentence at the end. This is limited to those customers with emails on file. And I think that addresses something that Cub said they're willing to do, and I think it makes it good. So that's my motion on the, I think one of the critical issues again is going to be Coyote Station, and I don't think it is a normal retirement of a plant. This is a different animal, and you are setting up a new division scheme between the Dakotas and ourselves of who pays for what. There was some discussion about the future on your battery, whether Minnesota is paid for that all. And I read an article that North Dakota is proposing a whole bunch of batteries in their state. So I don't know, maybe I don't know what's going to go on. So we're doing this as we go through each of these things, and I understand that. I would have preferred maybe that there would be a Otter Tail Minnesota and Otter Tail Dakotas, but I understand that doesn't make sense for your size of your company, and so we have to be very careful as we walk through each of these divisions. And I don't view Coyote as a retirement. I view Coyote as they're keeping it for their policy reasons and their policy reasons only, and we should only be paying depreciation through when we're no longer used and useful to us, and that the depreciation then falls either on North Dakota customers or whatever your other partners in Coyote can figure out. But I think that's when Minnesota's depreciation ends. I would not be in favor. I sit here now today, and again, I need to look at the law and the record and have that fully developed. But as I sit here today and looking at how the scheme that you have set up, I'm convinced that Coyote's future ongoing depreciation from 2031 to 2041 belongs to somebody else and not to Minnesota ratepayers. It's not our responsibility. Had you been closing the plant down, which is what we would have liked, of course, North Dakota would have sued us for violating some dormant commerce clause or something if we forced it to happen. Then I would have a different opinion, but we're not closing Coyote. Coyote is staying open for policy reasons for them. And who knows, a policy could change, in 3 years here in Minnesota, or in a year and a half, by the time we get the rate case back from us. I don't know, but I'd be surprised if it was. And so that's my thinking. I get it's a risk. I get it's a risk that OAG is willing to take, that it might be more for ratepayers, but there's also risk mitigation tools that we could use if we do determine Coyote should, the remaining 10 years of Coyote should be paid by Minnesota ratepayers under some theory that makes sense. And this theory is different than standard, accounting principles. This is a theory you've coming up with on how we divide up our responsibilities within your service territory. And so that's how I view it. I don't view it as a as a accounting issue. I view it as an appropriate, who is responsible for that cost and how should that be paid? So that's how my thinking on Coyote. And so that's my motion, Mr. Chair.
Thank you, Commissioner Tuma. I appreciate you walking through that. And actually, this conversation around Coyote has been helpful as I've kind of been thinking out loud. And what you just said there is very interesting. I think very thoughtful. And I'll be really interested to see, how this develops in the rate case. So, yeah, thank you for the motion and thank you for expounding on that, because I think that's an interesting line of thought, Commissioner Tuma. Commissioner Partridge. Mr. Edstrom.
Sorry, I should have mentioned this earlier, but I'm also just hoping the commissioners might address our petition to intervene. In a motion.
Did I approve that? Oh, no, I think we assumed it was approved. That's what I was told in my briefing, is that they're not objecting to it. It's approved. But if you want me to say specifically Cub should be able to intervene, and it makes you feel better, I'm good with adding that to my motion.
Well, thank you, Commissioner Tuma. I suppose that in the chance that we work with an ALJ who's not familiar with Cub, that might be helpful to have that clear from the commission.
24 is we approve Cub's petition to intervene as agreed to by Otter. That way we're very clear to the ALJ, you're good.
Thank you, Mr. Edstrom, for catching that. All right. Commissioner Partridge.
No questions.
No questions? How about a vote?
Yes.
Commissioner Tuma?
Yes.
I also vote yes. Thank you to the parties. Thank you, Ottertail. Have a safe trip home to Fergus and
stay warm.
Stay warm. And
we got one more.
We have one more.
Right.
We have a belt and suspenders. Get this done. Delegations.
I have lots
Thank you.
Lots of questions about this.
3 hours and you're going to be getting
Just kidding.
into Winnie's.
I'm joking.
Thank you, Mr. Adnesio and Mr. Schultz and Mr. Edstrom. All right. Our third and final item for the day. Ms. Rogier.
Good afternoon, Chair Sullivan and Commissioners. Item number 3 is docket number U999-PR25-16 in the matter of Commission Subcommittee Delegations under Minnesota Statute 216A.03, Subdivision 8. The question before the Commission are, what action should the Commission take on the Commission Subcommittee Delegations for the regional transmission organizations, and what action should the Commission take on a proxy for NERC voting ballots? I have no further remarks, but I'm available for questions. Thank you.
Thank you. I'll just say I'm happy to make a motion. I think that this is memorializing, what we have been operating under already. My delegation to OMS and MISO, and Commissioner Tuma, your delegation to the RSC and SPP. Just want to make sure that we're keeping this kind of evergreen and bringing it back up to the Commission for approval. Since this is a little bit of an interview, I've really enjoyed my work on OMS. I think I've done a good job for the state of Minnesota. And Commissioner Tuma, since it's your interview too.
I don't know if I've done any good, but I've certainly caused a lot of problems. Let's put it that way.
Well, all right. Now, Commissioner Partridge, now is your turn.
I would just say thank you both for all of the work you do in addition to your normal day job to engage with the RTOs and make sure that Minnesota is getting what we need out of the transmission system. And so thank you both, and I will happily vote to reappoint you.
Great, thank you. Anything additional? Are we?
So that would be decision options
1 through 4. I was just about to move those. All right, I will move decision option. Mr. Graham, is the motion clear? The motion is clear. All right. I will move decision options 1 through 4. And with that, Commissioner Partridge.
Yes.
Commissioner Tuma? Yep. I also vote yes. The motion passes. Thank you, everybody. I think it's only the department and commission staff in here now, so.
Oh, wait, I see XLC still.
All right, he's, okay. Yep, there's Al.
Al.
All right, thank you, everybody.
Take her easy,
Have a
Al.
nice weekend. The hearing is over.